Okay, so thank you for your patience. We are here tonight for a special town council meeting. It's September 30th, a little bit past 5 p.m., 5:08 p.m., Women's Club, 46 Park Road, Fairfax. So I would like those who would like to join us in a pledge of allegiance to do so now. Thank you. Okay, thank you. And thank you for your patience. We want to make sure that this is recorded and that also people who could not join us in person tonight can participate. So that was important. I want to also welcome the Planning Commission since this is a joint meeting. And I'm going to slow down a little bit here because I see one of our commissioners walking up the way. So we'll let her come in and get settled. And I am going to, while we're waiting, read the land acknowledgement. So the Fairfax Town Council acknowledges that we are located on the unceded ancestral lands of the Coast Miwok people of present-day Marin County. We honor with gratitude the land itself and all its ancestors past, present, and emerging. Right. Okay, so I'm going to read the meeting protocol. So the mayor shall maintain order at the meetings. The council has the responsibility to be a model of respectful behavior in order to facilitate the conduct of the people's business and encourage civil engagement in town council meetings. The council and the audience are expected to refrain from using profane language and/or ridiculing the character or motives of council members, staff, or members of the public, and to maintain the standards of tolerance and civility. Please turn off all cellular phones or place them in silent mode. Shouting, clapping, booing, stomping, or other disruptive behavior during public comment or council deliberation is discouraged in order to provide a respectful and comfortable environment for all residents to express their point of view. Clapping is, of course, acceptable when we're doing items such as police pinnings, proclamations, welcoming new staff and council members, and other celebratory announcements. So the town council will review the agenda at 10 p.m. Hopefully we don't go that far, but you never know, to ascertain which items, if any, will be continued to another meeting. Any matter not started by 11:30 p.m. will be continued to an adjourned or regular council meeting unless the council votes to suspend this rule. So I'm just going to reiterate that this is a special meeting, so there's no open time for public expression. We will have a presentation followed by clarifying questions from the council and planning commissioners. We will then move to public comment on this item only. After the public comment, I would like to, at some point, read back questions from the audience to the presenters, and council members will also, and commissioners can then ask more questions and, deliberate or make statements. There's no action on this item. Okay, so I'd like to turn it over to our planning director, who I believe is going to kick this off. So welcome, and thank you, Jeff.
Great. So we have a PowerPoint here prepared. So
it's very, very faint. So if you could get it closer to you. Yeah.
Yeah, I'm too tall for this microphone, I think. So tonight we have Barbara Kautz here with us, who is a kind of a housing law expert and who keeps careful track of all of these all the laws that the state legislature passes from year to year from the firm of Goldfarb and Lippman. And I'm going to give just a really brief overview of kind of our housing element adoption, and then I'm going to pass it off to Barbara. So if I can go to the next slide. And the next slide after that. So we adopted the current housing element in December of 2023, and then it was certified by HCD in April.
As few acronyms as possible. Please.
Oh, yeah, sorry.
Thank you.
The State California Housing and Community Development Department certified it, which is required by the state. And just to explain that it's called the housing element because it is one element of the town's general plan. The town is required to have 8 elements or at least cover 8 topic areas. Housing is one of those. The others are land use, circulation, conservation, open space, air quality, noise, and safety. And you may also recall that we recently adopted a new safety element and land use element, also to comply with state law and those updates were kind of required to follow the housing element update to ensure consistency. If you go to the next slide. So just a little overview on what the housing element requirements are. They're updated on an 8-year cycle. We're currently in the 6th cycle, and kind of each region of the state kind of updates them in different time periods. And so this region's update was this over the past couple of years. So our key dates again are we adopted the housing element on December 13th, 2023, and then we had to do some technical updates, and then it was certified on April 2024. The basic legal requirements are provide programs to preserve and improve and develop housing, identify housing needs for all economic segments, and then the one that folks tend to focus on is identify adequate sites to meet the share of the regional housing need. And also what we're going to be talking about tonight is provide a housing element that complies with state law. And there is a mandatory review by the Department of Housing and Community Development, and that's what that certification is all about. Next slide. So this is what we talk about when we refer to the regional housing needs allocation. This is all of the localities in Marin County. You can see that our RENA for this 8-year cycle is 490 units. And then the other jurisdictions in the area are there for comparison purposes. So the total for all of Marin and all the jurisdictions is 3,569 units.
I'm sorry, the total for Marin, isn't that?
For all of the.
That's just unincorporated, it's 14,000.
Oh, sorry.
Yeah.
Yes.
Thank you. Sorry to interrupt.
Yeah, sorry. I was misinterpreting my own chart. Yes, so that is correct. Next slide, please. So, and again, I'm just doing a real brief overview of the housing element process, which was, we covered in meeting after meeting after meeting. So this is just really just intended as a snapshot introduction for Barbara's presentation. But in our sites inventory, which is part of that housing element requirement, we have identified a capacity for 598 housing units. We're not suggesting or nor are required to that number of units is built. That's just the capacity that we have for the vacant land that's or redevelopable land that's available. And so we have enough sites identified to meet the 490 unit RENA requirement with a 22% buffer, because it's expected that certain sites will not develop, they'll be used for other purposes. And that buffer is required for what's known as a no net loss provision of state law, where if a site is used, say if we have a site identified for residential development and it's developed for commercial, then you'd have a buffer available to fill the gap, because that site is no longer available for residential purposes. Next slide. Oh, and yeah, well, it's here on this slide anyway. And so one of the things that we did to satisfy the RENA is we created what's called the workforce housing overlay. And the purpose of this was to not kind of identify an entire zoning district which would accommodate housing, but to really just select sites that had willing property owners who were willing to put their sites up for consideration for residential development. And so we came up with the workforce housing overlay concept of the WHO A and the WHO B. The WHO A is the more intense development, and then the WHO B is kind of the less intense development, but all of them would qualify for additional bonus density units if they provide low income housing units. Next slide. So, but just to emphasize, the housing element isn't just about RENA. The housing element contains a housing action plan, which calls for housing range, housing options for all economic segments. It calls for the eventual creation of a town center plan, has a program for home sharing, tenant matching. I'm just picking a few. ADU and JADU awareness. There's also programs that address regulatory process and market factors that limit housing, such as processing permit procedures to expedite housing. Zoning and subdivision requirements were adjusted, and then we have programs for other things that might make development a little bit easier, such as focused geological studies in the town center area is one of the programs. And then there's also requirements to promote housing for special needs populations. Next slide, please. And so with that, I will pass it off to Barbara Kautz to go over some of the recent California housing laws.
And the planning commissioners. Since 2017, the state's actually adopted almost 500 statutes designed to help the state overcome its housing crisis and to speed up the development of housing. Frankly, it's impossible even for those of us who only deal with housing laws to keep up with all of them. And they have really been like an avalanche on local government. What I'm going to try to do is just to focus on the laws that I think have the most impact on local government and on the ability of local governments to modify housing development projects. So next slide. So what I'm going to talk very briefly about the state housing policy. Going to talk about the Housing Accountability Act, which is one of the major bills that tries to promote housing. I'm going to talk about density bonuses, a little bit about your ministerial approval in the workforce overlay zone. And then in July, the state adopted immediately as part of the budget bill some very significant additional bills to try to streamline and make it easier for housing to get developed. I'm going to talk about the history to date of litigation, the Department of Housing and Community Development in the courts, and then a bit about what are actions that cities and towns can take to maintain local control to the extent possible. So next slide, and then the next slide. So this language was adopted back in 2017 when the legislature got on their, started to adopt more and more bills to try to solve the housing crisis. And basically what it says here, and this is a part of the Housing Accountability Act, is that the legislature's intent was to meaningfully and effectively curb the ability of local governments to deny, to reduce the density of, or to render infeasible housing development projects. And at the time, the legislature said this intent has not been fulfilled. So it's helpful to think about all this legislation as an effort to make it very difficult for local governments to deny or reduce the density or make infeasible housing developments. So next slide. So let's see. I'm not sure who's running the slides. Great. Go back.
That's the wrong one.
Back.
Back.
One
Back.
more. I'll start here. This legislation is all generally contained in the Housing Accountability Act, which for practitioners is probably the major piece of legislation that affects housing approvals. So a bill passed in 2019 called the Housing Crisis Act established something called preliminary applications. And so a developer can submit something called a preliminary application that's basically an abbreviated planning application that has very limited requirements. But by doing that, the developer freezes the development standards as of the date the preliminary application was submitted, provided that it has all the information that it's required to have. Now, now to maintain what's called that vesting or freezing of the standards, the project does have to meet certain timelines. A real project application has to be filed within 180 days, and then the application has to complete the application within 90 days of receiving an incomplete letter. That's, a letter from the city saying that, well, your application doesn't have everything it's required to have. The interpretation of that is the subject of some extensive litigation right now. So a preliminary application can be submitted for any housing project of any size. And the effect of this is that even, if an application is submitted and the town suddenly thinks, gee, we missed something, we'd like to amend our ordinances, you can't do it. Everything's frozen in place as of the date that preliminary application was submitted to the town, provided it has everything it needs to. Next slide. Another limitation is that the town can only have a maximum of 5 public meetings on any housing project once the project is determined to be complete. And what that means is that the city has an application form for housing and anything else. And application's complete when it's submitted, everything that's on that form. So after that happens, after the application is complete, the town can't hold more than 5 public meetings. And that includes continuances. For instance, even if the applicant requests a continuance, the city doesn't have to grant it, but that continuance will count. It includes appeals. It includes any meeting organized by the town. It also applies to single-family homes. If a project requires what's called a legislative action, which is a change to the general plan, a rezoning, then the 5-meeting limit doesn't hold, but it holds for most housing projects. Next slide. And the key provision of the Housing Accountability Act is that the town can deny a housing project with 2 or more units only if, one, it doesn't comply with objective standards, and I'll talk a little bit more about those and some exceptions, or if the project is determined to comply with objective standards, then the town has to make a finding that it results in a specific adverse impact on public health or safety. And that's defined as a significant, quantifiable, direct, and unavoidable impact based on objective, identified, written public health or safety standards that can't be mitigated. So first of all, even if there's a health and safety impact, if the town doesn't have an adopted standard that was in effect when the preliminary application was filed, it can't use this provision to deny the project. I worked with a city where residents presented evidence of an impact of the project on evacuation time, but the city had no standard about fire evacuation time. And so they could not use that to make any changes in the project. There have been a number of cities that have tried to make this finding. The hearings have all been in Southern California Superior Courts, but generally they have failed because the city didn't have a finding, an adopted standard that was effective in advance. So this is a very limited provision. Next slide. Then, if the project qualifies as affordable, and based on changes that were made last year, an affordable project is one that has either 13% low income, 10% very low income, 7% extremely low income, or has 10 or fewer units at a density of at least 10 units an acre on a site smaller than an acre. So if the project's considered to be affordable, next slide, additional findings need to be made to deny it or to adopt a condition that the applicant might say makes the project infeasible. One is a specific adverse impact finding. If it doesn't comply with state or federal law, inadequate water or sewer, zone for agriculture, and so forth. It can also be denied.
Excuse me, Barbara. I think someone has their Zoom on, so we're hearing kind of a double. Okay.
Yeah, I was starting to, yeah, thank you.
Barbara, are you going to later in the presentation get into specific adverse impact? You're going to expand on that a bit?
Sure, I could talk about that more if you want to go back to that.
And
Well, it's just the second bullet here. Just, I think, for the public, just an example or defining that.
I'm sorry, it's the same standard I read before. So the specific adverse impact, again, is a significant, quantifiable, direct, and unavoidable impact based on objective, identified public health or safety standards, which must have been adopted when either the project was found to be complete or the preliminary application was submitted, that can't be mitigated. So if the impact could be mitigated, I'm dealing with an issue now where someone doesn't want to put in a sidewalk next to a 4-lane high-speed road. So that seems like pretty clearly a health and safety standard, right? But it can be mitigated by making the developer do it, saying you have to do it. So to actually deny the project, not only does it have to violate the standard, but there's no way that the standard could be met. And so for an affordable project, that's the same finding that would need to be made. Now, an affordable project can also be denied if it doesn't comply with both the town's zoning and the town's general plan. But that finding can't be made if the town doesn't have an adequate housing element. And the legislature has changed the definition of what's an adequate housing element to mean one that the Department of Housing and Community Development has approved, or a court approves. But either HCD or the court must approve the housing element for it to be considered consistent with state law. The city can't just say, hey, we have good grounds here for thinking our housing element complies. If neither HCD nor a court has said it complies, then it's considered not to comply. So that's what people call the builder's remedy, which some of you may have heard. And the developers that I don't need to comply with anything, right? Because you can't turn down my project. That's basically how it's been interpreted. Next slide.
Excuse me, Barbara, you didn't cover everything on that slide. Were you planning on that?
Pardon?
You didn't cover the other things, doesn't comply with state or federal law, inadequate.
Oh, I thought I went through
I think we just focused on the first one.
Oh, okay. I talked about the specific impact, adverse impact. This is for a project that qualifies as affordable, or if it doesn't comply with state or federal law, or if there's inadequate water or sewer, or if it's zoned for agriculture or resource preservation and surrounded on two sides by sites that are actually used for agriculture or resource preservation. So next slide. So the definition of an objective standard that the legislature has adopted is that it's a standard that involves no personal or subjective judgment by a public official, and is verifiable by referring to an external benchmark. So Generally, standards that are considered objective are density requirements, how many units an acre a project is entitled to, what the height limit is, how much of the lot can be covered, how far the project needs to be or the building needs to be from property lines, those are setbacks, and floor area ratio requirements, meaning the amount of floor area that a developer is entitled to given the size of the lot. Subjective standards are really, frankly, what communities often use in terms of evaluating design, reflecting look and feel of the community, site's not physically suitable for the use, has to be compatible with adjacent uses. All those are considered to be subjective. Now, the town can try to define those. For instance, you could define the look and feel of the community as, craftsman style, or in Santa Barbara, you can think everything has to be kind of a mission style. And my understanding is they have a very detailed book of guidelines explaining what mission style is. So the town could do that to try to convert some of these into objective standards. But a project can't be denied or have the density reduced for failing to comply with a subjective standard. Next slide. So this is actually a diagram from a published case, Carla, let's see, California Renters Legal Assistance versus the City of San Mateo. And so the project was denied, and the city attorney said that this was an objective standard. And it said if the height varies by more than 1 story between buildings, a transition or step in height is necessary. And there was actually a diagram showing what was, what was expected. And next to this proposed building on the right, there was a 1-story single-family home. So you can see that the height certainly varied by more than 1 story between the buildings. But the court said the standard was not objective. Next slide. Because the transition could mean some trees and a trellis that was shown in the plans instead of a setback. And it wasn't clear how far the upper floors had to be stepped back. It wasn't clear how, whether the step back was just for a little bit or had to run along the whole length of the building. And it wasn't very clear how many of the floors needed to be stepped back. Another problem was that staff and the consultant had concluded that the project conformed to the standard, but the Planning Commission and Council disagreed. And the court said both interpretations were reasonable, which the court construed as proof positive that it wasn't objective. Since there were a variety of interpretations you could make, then it wasn't an objective standard. But the court in this case did have one caveat that was helpful, could be helpful. They said the town could have imposed a condition of approval to make the floor step back rather than denying the project, that would have been the appropriate thing to do. Next slide. So in terms of reviewing projects, as you can see, there's a pretty strict standard for objective. Because of a later adopted bill, only subjective standards adopted before January 1st, 2020 can be used to apply conditions, but they can't result in reducing the density or effectively denying the project or make an affordable project infeasible. And they can't be used on what I'm calling a by right project, which I'll explain later. But here's the problem. So cities and counties then spent a lot of money at developing objective standards. But under the density bonus law, which I'll talk about, developers can obtain waivers of most standards so that all the effort that communities put into developing objective standards, if the developer doesn't want to follow it, essentially the door is open. So next slide. One other tool that communities have to modify projects is the California Environmental Quality Act. And so if a project requires what's called discretionary approval, meaning it has hearings, the city, the town can look at it and try to decide it. Then it might be subject to the California Environmental Quality Act. But the legislature has adopted many, many provisions that allow what are called ministerial approvals, meaning they're supposed to be treated like building permits. There's accessory dwelling units, which you probably know, SB 9, which allows 4 units on any single family lot. A bill called AB 2011, which allows housing in commercial zones. So the legislature has adopted more and more ministerial approvals that can be used where essentially the California Environmental Quality Act can't be used. They've also, even for projects that might require a discretionary approval, they've created now many, many more exemptions. And the law that was just passed that became effective in July basically greatly expanded those exemptions. Now, if the project's not exempt, the town can apply mitigation measures, but the legislature has tried to limit more and more the application of CEQA, the Environmental Quality Act, to housing. Next slide. So there was a question about whether there was an application, any difference in application of these bills to charter cities versus general law cities. Fairfax is a general law city. Charter cities are subject to what's called the municipal affairs doctrine, where they are supposed to have control, much more local control over things that are only a municipal affair. So the legislature has adopted findings in almost virtually all the housing legislation, making the bills applicable to both charter and general law cities. A number of cities have tried to challenge this bill, tried to challenge these findings, and there's been only one charter city success in the trial courts, and that was related to SB 9, which is the law that allows 4 units on any single family home lot. The case is now on appeal, and the legislature has adopted new findings to try to correct the reason that the cities won in the trial courts. But the case hasn't come down yet. And the reason that the cities were successful is that if you're going to take away local control, it has to be related to the statewide problem you're trying to solve. And the state in its findings for SB 9 talked about wanting more affordable housing. And the city said, yeah, but there's nothing that requires these units to be affordable. And the trial court agreed with them and said, yeah, this wasn't, the law's not really tailored to the problem. But the legislature then adopted revised findings saying, well, we just wanted more housing. So it'll be interesting to see what happens on that case on appeal. But to date, that's been the only success. Next slide.
So sorry, I have a question.
No,
on that.
please.
So there's no, with regard to charter cities, there's no other litigations out there
Not that I'm aware of.
related to housing?
Yeah.
Okay.
I mean, Huntington Beach has.
Yeah, we're well aware. Yeah.
Huntington Beach has made extensive efforts, and they've generally been losing.
Right.
Yeah. I mean,
Excuse me, Mayor, may I say a word while we're talking about charter cities? The charter cities in Southern California, there's 2 litigations going on.
okay.
And one is in federal court on its way to the U.S. Supreme Court. That's one of them. The second one is the one that AG Bonta has appealed, and that's in the Second District
you.
Court of Appeals.
Right,
you.
I think that's the one I mentioned, right?
Thank
But
you.
with
That's the
just
one you're
nine.
talking about.
Yeah.
There's a second federal lawsuit
Right.
going on
I
too.
forgot about that. Yes, thank you. Yeah, I think it's also Huntington Beach, correct? Yeah, yeah. So just density bonuses. So next slide. So any project that has as little as 5% affordable housing can qualify for a density bonus. And depending on the amount and the affordability level of the housing, of the affordable housing, they can receive a density bonus of anywhere from 20 to 100%. So that means if the town would normally allow, say, 10 units on the site, depending on how much affordable housing is provided, somebody might actually be able to build 12 to 20 units on the site. Also, if the site's affordable, if it's 100% affordable and close to a major transit stop, which I'm not sure exists in Fairfax, yeah, okay, then it has unlimited density. A project is also, again, depending on the amount and the type of housing, entitled to anywhere from 1 to 7, what are called incentives and concessions. And they're changes to development standards to reduce costs. So when I mentioned the developer who didn't want to provide the sidewalk, he's requested a concession not to put in the sidewalk because that would obviously save him money. Developers are also entitled to an unlimited number of waivers of development standards. They can ask to waive setbacks, height, floor area, coverage, any standard the city has. They can request an unlimited number of waivers of those standards. And in the most recent appellate decision on it, the Court of Appeal decided, this was in the 6th District in San Diego County, that cities must grant waivers for the building as designed unless it can make certain findings, which I'll get to. Density bonus law also also has provisions for reduced parking requirements. And then, most significantly, the statutes say that a project that receives waivers, concessions, and bonuses is considered to be consistent with the town's standards. So it cannot be denied for failing to comply with objective standards, even though, in fact, it might not. And then the town must make that specific health and safety finding to deny the project. In addition, many exemptions from the California Environmental Quality Act require that the project conform with local standards. And because a project with all these modifications is considered to be consistent with local standards, it might also qualify for an exemption from the Environmental Act. Next slide. So concessions and waivers can only be denied if the town can make that specific adverse impact finding that I read before, or if the concession or waiver violates state or federal law, or if it has an adverse impact on a project listed on the California Historical Register. Concessions can also be denied if they don't result in identifiable and actual cost reductions. But those are the only reasons that these concessions and waivers can be denied.
Could you explain what California Register means, please?
Sure, sorry. So the California, let's see, it's the Office of State, anyway, there's a state historic office, and they maintain a list of historic buildings. So there also may be local listings. Many cities have their own local registers, this building is locally significant. But in terms of concessions and waivers, only projects that are listed on the state register can be protected. And then how do you get a building on the state register? There's a whole application process.
And does it include Native American sites that have significance to?
It can. But yeah.
Thank you.
Excuse me? For the waiver category on concessions, if the project doesn't result in identifiable and actual cost reductions, cost reductions for who?
The developer.
Okay.
Yeah. I mean, the project, right? It reduces the cost of the project.
Mr. Bell, are you trying to? Okay.
Yeah, sorry, Barbara, just a couple questions. So on your slide that covered the definition of affordable, one of those categories was a project that has 10 or fewer units at a density of at least 10 units per acre. Is that in addition to those other below market rate requirements, or a project can independently be 10 units or less and qualify as affordable?
No, to qualify for a density bonus, you actually have to have affordable units. So like the 10-unit project would need to have at least one affordable unit.
Because it has to have some.
Yeah, they're
So they're tied together. Okay.
yeah.
And
The 10-unit, the small 10-unit project, that only applies in terms of the kind of findings the town would need to make to turn down the project.
Great, thank
But
you.
in order to get a density bonus, there actually has to be some affordability.
okay, thank you. And then
Thank you. Okay.
second question is on in the cases where there's a ministerial approval.
Can we hold questions till the end of the presentation?
Okay,
Yeah,
sure.
sorry, it started going, and then I thought maybe we should just let her get through the presentation. So if you could hold that would be great.
Next slide. So the town requires affordable units, 15% low in rental projects or 20% very low in for sale projects. So all those projects become eligible for a density bonus, plus waivers, plus concessions and so forth. The legislature even changed the law where even if the project doesn't want a density bonus, says I don't need it, they can still apply for waivers and concessions. Next slide. So something that's, so the legislature, when they adopted the housing element law, they also said that any site that had to be basically upzoned in order to accommodate low-income housing had to be, was eligible for what they call by right approval. And so to be eligible for by right approval, a project needs to have 20% of the units as low-income units. That's a fairly high number. But the town's approach to this, next slide. So the town's approach to this was to create the workforce overlay zone that allows these ministerial approvals. And so regardless of what kind of, quote, by right approval is, what process the town has for by right approval, if the project qualifies, there's no review under the California Environmental Quality Act, and the town can only impose objective conditions on the projects. And as I said, it applies to sites that were upzoned for lower income housing if the project has 20% lower income units.
Could you quickly say what by right means for folks in the crowd who don't know that?
Right. By right means that the project has 20% lower income units and was upzoned, and then the by right approval means there can't be any review under the California Environmental Quality Act, and the town can only apply objective standards.
Okay, so that doesn't mean ministerial, or does it?
Not necessarily.
Okay, thank you.
Yeah. I have some, yeah. I have some clients that have a different, have these projects have design review.
And if people are wondering why I'm asking now, I'm trying to keep the questions till the end, but I want to make sure that when we use language that is maybe more common for planners and administrators, that the rest of the people in the room know what it means. Thank you.
Yeah, sorry. I'm trying to keep the jargon down, but it's hard. Next slide. So in the town, the workforce overlay zone is subject only to design review by the town staff. In that case, the planning and building director reviews it. The project has to be approved if it's consistent, which is actually like the rest of the law, whether or not it's ministerial or not. And it's placed on the planning commission agenda as a consent item. Next slide. So there actually have been, so the governor apparently, as a condition of adopting the budget, insisted that the legislature adopt legislation that would greatly expand exemptions from the California Environmental Quality Act. So those bills went into effect immediately when adopted on July 1st of this year. There have been another about 60 bills passed. I would say most of them are much more minor, but so the big bills in 2025 were the ones that went into effect in July. Next slide. So the biggest one is this broad new infill exemption that was adopted. People call it the AB 130 infill exemption. So housing projects in the town are exempt from review under the California Environmental Quality Act if the site's not more than 20 acres, if it was previously developed with an urban use or 75% surrounded by urban uses. There's a number of tests, you know, like if the development within a quarter mile is urban. Anyway, it has to be within the town limits. It has to be consistent with the general plan and zoning. But again, it has this language saying that if the project is eligible for waivers and concessions and bonuses, that's considered to be consistent with the general plan and zoning. The density has to be at least 10 units an acre, and it has to meet certain environmental standards. It can't be on a site that's habitat for protected species. It can't be on a site that contains wetlands. It can be in very high fire hazard zones, in floodplains, in hazmat sites. There's one more. Oh, earthquake zones, if certain mitigation measures are part of the project. And the project can't demolish historic resource listed on either a local or the state register. But it has to have been listed before the preliminary application was filed. So we were assisting a city that had decided they wanted to do a EIR on a building that they considered that was going to be demolished, that the city considered to be historic, but it wasn't on any register. Then AB 130 adopted, and the developer met all the other requirements. And so even though this building, where there was pretty substantial evidence, was historic, because it wasn't on any register, they couldn't save the building. So next slide. This infill exemption also has a whole tribal notification process. The tribes have 60 days to respond, and the whole consultation has to be finished in 45 to 60 days from when it starts. But the real issue here is that the town then has to approve or deny the project within 30 days after the tribal notification is complete. The appeals aren't included in the 30-day limit, so if something, goes to the planning commission and then would need to be appealed to the council, that's outside the 30-day limit. Developers can also grant a 90-day extension, but but again, it really, really limits the opportunities for public input. Next slide. And then about litigation of the housing and community development and the courts. Next slide. So HCD, I'm sorry, do you mind if I use HCD? So the Housing Community Development Housing Accountability Unit has at least 25 people. I think they have more actually now. They've been given broader and broader authority. They typically act under two circumstances, one or three maybe. One is if a developer doesn't like an interpretation of a statute he's getting from a city or a town, the developer will complain to HCD, and HCD may or may not agree with the developer, but will write the town a letter of technical advice if they disagree with what you're doing. They have a spreadsheet you can get online that has literally hundreds of these letters that they've written. Some cities and counties, if they have a question and they decide they want to be protected from litigation, may write HCD itself and ask for an interpretation. They also have a proactive enforcement unit. And to date, their focus has been on communities that haven't adopted housing elements and communities that haven't done the rezonings that were promised in their housing elements. They've sued, I just saw a settlement agreement with the city of Artesia, which I'd never heard of. It's a small 16,000 population community located, it looks like it's located in eastern LA County. There were also issues with Coronado. They also sued or have a settlement agreement with Coronado. And of course, they've sued Huntington Beach. In that case, there was just a Court of Appeal decision that said the judge made, the trial court judge made a mistake because she didn't, one, set a deadline for Huntington Beach to adopt its housing element. It's supposed to be a 120-day deadline. And she didn't impose any penalties, which the statute says that are to be imposed, which are either ordering the city to approve certain housing projects or telling the city it can't issue building permits for certain kinds of projects. The Attorney General can act, sometimes HCD refers cities to the Attorney General, or the Attorney General can act on its own. So anyway, next slide. HCD also has the authority to, quote, decertify a community's housing element if it's not implemented as promised. I mentioned that they were particularly going after communities that hadn't adopted the zoning they'd promised in their housing element. A friend of mine told me she'd just gotten a letter. So in Fairfax, there's supposed to be a January 2026 review of accessory dwelling unit production, but that doesn't look too serious. But if HCD decertified the housing element, and remember I said that they changed the state law, so if HCD hasn't approved your housing element, you're not considered to be in compliance, then it would subject Fairfax to the builder's remedy. And looking at a map, this is approximate, it looks like sites in the town approximately west, I think the direction's west maybe, on the other side of Sir Francis Drake, could be built with a base density of 65 units an acre, which could be doubled with a density bonus on approximately this side of the freeway, they could be built at about 30 units an acre. And then there's language that's saying builders remedy projects are considered consistent with local laws, so they could qualify for the new exemption. And there's a lot of provisions about these builders remedy projects that the legislature adopted that really let them almost do what they want. In fact, there's a provision that says you have to approve it as proposed by the applicant. Next slide.
I'm sorry, could you repeat those numbers
Yeah.
for I think you were talking about
The
the
build-
north
the
of Sir
build-
Francis Drake and south of Sir Francis Drake?
Yeah, on the other side of Sir Francis Drake. I looked at so what it is, so the minimum, so the density is at least, so the density is the base density is the greater of 1.5 times what's called your default density, which I think in Fairfax is 20 units an acre, or 3 times the actual density you allow, or let's see, or the density shown in the housing element, whichever is greatest. So for any site can get at least 30 units an acre. But if the site's in what's called a high or very high opportunity area, it's shown by maps that the Tax Credit Allocation Commission has developed, then it gets another 35 units an acre. And it looked, when I looked at those maps, that the area generally on the other side of the freeway was high opportunity.
You mean the
and
other, we don't have a freeway. You mean Sir
I'm
Francis
sorry, did I
Drake?
say freeway? Sir Francis Drake, yeah. It looked generally like the area on the other side of Sir Francis Drake was rated high opportunity, and on this side, moderate opportunity. So if what I've interpreted is correct, then the sites on the other side of Sir Francis Drake could get the 30 units an acre plus 35 more for being in a high opportunity area. On this side, they just get the 30 units an acre. But if there's a site where 3 times the existing density is more than 30 units an acre, they could get more.
Thank you.
Next slide. So there's a lot of third-party litigants out there. One of our clients has some litigation in Santa Clara County, and all three of these YIMBY groups collaborated in the trial court on an amicus brief saying why our client was wrong. And then we've seen a lot of developers' attorneys become more and more aggressive, demanding, and challenging. Next slide. And they've been winning. The courts in general have been very pro-housing. They tend to uphold housing approvals and they tend to overturn denials. It's very unusual for a city in this climate to be successful. The other problem is if a community loses in the trial court, they generally can't appeal because there's a bond provision. So this has been mostly interpreted in the LA County Superior Courts. So in one case, you may have read about La Cañada Flint Ridge, which is a wealthy community in LA County, wanted to appeal an adverse decision, and were told they had to post a bond for $14 million. So they're not a very big city, so they dropped the appeal. LA recently, in one case, was told to put up a $35 million bond, and then in a second case, a $7 million bond. But even LA didn't want to risk a $7 million bond. So if cities lose in the trial courts, it's on a Housing Accountability Act claim, it's very difficult to appeal. The other problem is if the town loses on a Housing Accountability Act claim, there's significant attorney's fees exposure because the developer's attorney is entitled to collect fees from the town, his or her fees from the town. Huntington Beach was assessed 3.5 million in attorney's fees based on a case that they lost. And then there's a bill on the governor's desk now, AB 712, that I think's pretty draconian, which requires that the court fine the community $10,000 per unit if the community takes action and was advised previously by HCD or the Attorney General that that their action that an action was in violation of state law. So what can okay, next slide. So what can cities and towns do? And by that, I mean, what can you do to try to maintain, some local control? Next slide. Well, one is to adopt objective health and safety standards, because those are standards that you actually can enforce. Sidewalks, bikeways, street design, safe routes to school, anything that qualifies as a health and safety standard. The burden is on communities now to to do historic studies and designate those sites and buildings in advance. Because if an application is made before the site is designated, then you can't necessarily protect it. One of my clients has in their general plan standards requiring studies of environmental issues apart from CEQA. So those can generally be imposed, at least the requirement to do a study. Now, unclear about, what happens after the study is done, but generally that's been helpful. Again, you can invite, if a general plan has been adopted with mitigation measures, I think those can be imposed. But then what's really important is to contact your legislators, because it's not, these bills all come from the legislation, from the legislature. The legislature, I have my own, despite these 500 bills, the amount of housing being constructed in the state has not increased very much. In fact, this year it will decrease because of the high interest rates and everything else. The one big success has been the construction of accessory dwelling units. That has really gone up. That's been increased by like 10 or 20 times. So aside from, and they account, I think, in the last report I saw from the Department of Finance for like 20 or 25% of all the housing constructed in the state. But all these bills have not resulted in that much more housing being constructed. Yet the legislature appears to be convinced that if they, just make it easier and easier for housing developers to do what they want, that the problem would be solved, but that doesn't seem to be happening. And then next slide. And then in terms of project review, if the project isn't exempt from the California Environmental Quality Act, that gives the city, at least the town, some ability to have mitigation measures. You can enforce health and safety standards, you can enforce state and federal law, and you can protect historic sites if they're already listed. But there's the town's ability to affect the design of projects, of housing projects before it, has just been progressively limited more and more. And with that, I am happy to answer any questions.
Okay, so that's great. And, we wanted to hold questions to the end to make sure that she got through all of the material, but I wanted to make sure that first, before we move back to Mr. Bella, who started with a second question, if Councilmember Egger had had a chance to get his question fully answered about the charter cities or make what he wanted to did you have a further question about that, or were you able to get what you needed?
Well, the issue of charter cities, it's going through two processes. One is the state court, one is the federal court. And the charter cities down south are just waiting for their day in court to see where it ends up. And Fairfax has talked about it, and we're just going to wait and see what happens down in Southern California with those two lawsuits. Should those charter cities prevail in federal court, they may not prevail in state court, but they may prevail in federal court. Well, that's something we could take a look at.
Thank you. And Mr. Bella, did you want to continue? Sorry to have cut you off.
So thanks for the presentation. A lot of information. You know, I'm a landscape architect and urban designer, and I still can't keep up with all the terminology and all the changing laws. So it's hard to keep up with, but I think you did a great job. I have a question about the relationship between a project that still requires CEQA review and ministerial approval and conditions of approval. So can a project be eligible for ministerial approval and still require CEQA review?
No, because CEQA, California Environmental Quality Act, says specifically that ministerial projects are not subject to CEQA. That's initially the legislature's idea about avoiding CEQA was to make more projects ministerial. Then they just decided to apply exemptions.
Okay, and then
but it is possible to apply conditions of approval. Cities do that regularly, particularly for larger projects.
yeah, that was my next question. So
Yeah.
a project can be eligible for ministerial approval, but the reviewing entity, planning director, let's say whoever it is, can apply conditions of approval on that project.
Yes.
Okay.
Yeah, there's a guideline by HCD, the Housing and Community Development, that says you can apply standard conditions of approval. And then often there's particular conditions of approval. For instance, one project was planning to build over an easement that somebody else owned, right? So you can have a condition that you've got to get rid of that easement. You know, the easement holder has to agree. Yeah. Yeah.
Other questions? Okay, yes.
Sharing your microphone here, I think. I have two questions for you. One of them is in the ministerial approvals in the workforce overlay zone. Once a project is approved, and if it's consistent, it has to go to the Planning Commission agenda as a consent item. And then the slide tells you that the PC, the Planning Commission, cannot take action. So I don't understand that, because what if we do not approve the consent agenda?
That's a particular, that's a provision that you have in your ministerial approval guidelines. So I think you could take it off consent, to be honest.
That was the next question. Yeah, you could take it off or you could abstain. There's all kinds of.
Okay, and I think the town attorney would like to say something.
Yeah.
Yeah, I'm happy to talk with you about that afterwards if you like, but yes, you can take it off consent.
Yes.
Okay. Thank you. Second question that precedes that a little bit. So this is for the concessions and waivers to get a density bonus. And it says that a concession can be denied if it does not result in an identifiable actual cost reduction. So one of the waivers could be, for instance, that you want to make your building taller. If you don't do that, the building is less expensive. So how is that defined?
Yes, the burden of proof is on the city. The developer really has to show hardly anything, right? There's a court case that says the burden of proof, if you want to deny a concession, is entirely on the city or the town to demonstrate that it doesn't result in identifiable cost reductions. What the developers will argue, and my understanding is that HCD has written letters supporting this argument, the developers will argue that a taller building makes the building more feasible and therefore enables the affordable units to be constructed. To my knowledge, there's not any court case that's tested that theory. But that's the, that's the argument that's being made.
So nobody has yet challenged that in any.
Nobody's yet challenged that.
Okay.
Yeah.
Thank you.
And by the way, I don't know all the, all the Superior Court, cases that may be challenging various things. But anyway, I haven't read about a decision like that.
Yeah, I was just curious because the way it's phrased is
Yes,
ambiguous,
Yeah.
to say the least.
yes.
Commissioner Newton?
Thanks very much for your talk. I really appreciate it. Do you have any examples of what might be considered an objective standard when it comes to evacuation?
This is not my area of expertise. I think it might be something about a time that it would take and how you would measure that. I mean, I've seen various studies which talk about, in the example I gave you, I think there was a fire expert who provided a report saying something like, in a fire, you have X amount of time to get out. The roads need to have this kind of a standard. And ironically, in all this, the Attorney General has actually sued cities and counties, I think, for approving projects that increased evacuation time and required EIRs, saying that it wasn't adequately mitigated or that the project was too big or whatever. But I personally, haven't seen it, but my sense is that there's a fairly substantial literature about it. Okay, yeah.
And then on that one, on that item, the burden of proof is also on this city.
Yes, with anything with the Housing Accountability Act and most of the other laws, they say specifically the burden of proof is on the city. Okay. And in findings that you might need to make under the Housing Accountability Act, not only is the burden of proof on the city, but the city has to prevail by a preponderance of the evidence, which is a stricter standard. Usually the city just needs to have substantial evidence, meaning even if the other side had better evidence, if the city's evidence was okay, the city's supposed to prevail. Here, the city has to have better evidence than the developer.
And that has to be presented, and then I'm sorry, Mr. Director. Okay, just a sec. So that has to be presented, or that evidence has to be there before the developer applies, right? So if they apply and that evidence isn't there yet, even if they find it later?
Not evidence, but the standard has to be there. The standard has to be there.
Thank you. And I'm sorry, Commissioner Swift, was that? Yes.
So a couple questions to the standard for evacuation times. Do you know of any jurisdiction that currently has standards?
No. No, I don't.
Okay. And you mentioned for a denial of an affordability project could be inadequate water or sewer.
Mm-hmm.
Can you define what that would be?
Hang on. Excuse me. Yeah, these have become my Bible. It used to be one, this all used to be one volume, and now it's two. Let's see what it says here. The housing development project is proposed on land which does not have adequate water or wastewater facilities to serve the project.
So that,
yeah, go on.
I'm sorry. So that could potentially be a site that would have a septic system and no water line? I mean, no sewer line out to that site?
Well, I think, there's various standards that apply to septic systems. We had one ourselves for many years. Unfortunately, I was glad to be on sewer. But you'd have to show that the existing septic system was, inadequate. Yeah.
Okay. And then do you know of any jurisdiction that has successfully defined a look and feel of their community as an objective standard?
I think, a lot of communities spent a lot of time doing objective standards, for various, Marin County has very complicated objective standards, so does San Rafael. But in terms of look and feel, I keep thinking about Santa Barbara, where I know, they've had very specific requirements about what a mission design is.
Okay, and that's more a design than,
Yeah.
yeah, okay.
Yeah.
And then my last question, you mentioned opportunity area maps.
Yes.
Where
So
would I find those maps?
if you just Google California opportunity areas, you'll probably get it, but formally they're on the website of the Tax Credit Allocation Commission.
Thank you.
Councilmember Garrett, did you have something to ask?
I was hoping we can open it up to the public.
Yeah, I
before
will.
we talk.
Yeah, we're going to do that, but first we're going to go through this round of questions from
Ask my
us.
questions after I hear from them.
Okay, that's fine. Just wanted to make sure you had a chance. And Councilmember Hellman?
Thank you. This has been a really good refresher and very educational. So thank you. I have a handful of questions. Just from a process standpoint, so with regard to the State Density Bonus Act, the applicant or the developer requests the waivers, right?
Yes.
So that they request the waivers and then the town says yay or nay, depending on the circumstance or right? Okay. And then it proceeds from there.
Usually it's reviewed along with the rest of the project. So when I've seen staff reports, I'm not talking about ministerial projects. The staff reports usually say, and the project includes a request for, X concessions and Y waivers, and the staff recommends approval. But you can't require a separate application for them. So they're usually wrapped up with the rest of the project, if that makes sense.
Yeah. And then you talked a little bit about by right and ministerial. A site that was previously on a housing element of the past, so not this
Yes.
current cycle, does that qualify as by right or ministerial? Can you clarify that? So I'm pretty sure you're aware of a current pre-application that the community is showing up here tonight to learn more about what's going on. So that particular site, I believe, was on prior housing elements of the past.
Right. I was trying to somewhat simplify it. So by right applies in two cases. One is where you had to actually upzone the property in order to create a site suitable for lower income housing. But if the site was it was used in a previous housing element, I think if it's non-vacant, if it was used in the previous housing element, if it's vacant, if it was used in the previous two housing elements, then if the town wants to continue to use it as suitable for lower income housing, then that site is also eligible for by right approval.
Okay. And that's per the state.
Yes, yes.
And is that where we are with School Street Plaza? I'm looking at our staff.
Yeah, School Street has been on several housing element cycles.
Okay. So it is by right per the state.
Yes.
Okay.
Yes.
Thank you for clarifying.
And if the town doesn't allow it to be by right, then the housing element can be considered to be inadequate.
Can I just make one clarification question? You were saying if it had not been used for housing, but if it had been used for housing previously, is there a difference?
I think it's like if it hadn't been developed. I'll look at the exact language and get it to you. Yeah.
Thank you. Thank you, Mimi.
Thank you. And
I'm not
okay,
done.
go ahead. All right. No, I'm saying
Okay.
this. Yeah.
And the low income definitions, those are defined by what agency?
Oh, the same agency, Housing and Community Development.
Okay. And we don't have any, the local jurisdictions have no influence over that.
No, in fact, I don't understand at all how they come up with their numbers.
Okay.
But in Marin, a low-income household of one is somebody who makes less than, I think, about 104,000 a year.
Yeah.
So,
Right.
yeah.
Yes, we get a lot of questions and feedback related to that. Okay, moving on. Can you help us understand what the similar circumstances were or conditions with regard to the California Attorney General filing suit against, I think you said Artesia, Huntington Beach, Malibu, were all these communities never had a certified housing element, or did they do something that got their certification pulled?
I'm not sure what the deal was with Artesia.
Okay.
Basically, Artesia apparently just hadn't done anything, and so they went after them. Coronado felt that it was impossible to meet their standard. I think they had a regional housing needs allocation of about 1,000 units, and they felt very strongly that the state hadn't taken into account all the military housing.
Okay.
You know, there's a big military base on there. So they somehow worked out a settlement with the Attorney General about it. I think I can't remember what happened. Initially, they sued to try to get their RENA, their housing, their allocation reduced. Anyway, then they said, well, we're not, then their mayor made a lot of comments about how they weren't going to do it. Then the Attorney General got involved, but eventually they reached a settlement. But I don't know the details. With Huntington Beach, the state had actually approved a draft of a housing element, but the city council refused to approve it.
Okay.
Let's see.
And then, just for the sake of common understanding for all of us listening, so a decertified housing element puts you into builder's remedy status, correct?
Yes.
Okay. And so you went on, and I was trying to take notes. Are there projects like this in flight today that you're aware of where
I have one very nice high-income community in the Silicon Valley that has 14 builders remedy projects.
14 builders remedy?
Yes, some of them are like 13-story buildings in single-family areas.
Okay. So it's very real.
Yeah.
Because is there a resource where we can find, because I've been personally searching, where we can find these types of lawsuits and find builders remedy projects? It's difficult. Is there an agency, a public agency or a nonprofit or anybody tracking this stuff?
No, I'm not aware of that.
Okay.
There's a law firm, Holland and Knight, that argues that I've been on panels with them where they say they have clients with 50,000 builders remedy units in builders remedy projects. So, some of the YIMBY groups actually have lists of builders remedy projects.
Okay.
Maybe the Holland and Knight website would have it.
Okay.
My client's website, actually, I don't think they'd want their name, but they actually, for their public, they have a very expansive website that talks about all their builders remedy projects.
Okay. And then I'm coming to the end. Thank you for your patience with me.
That's okay.
The 10,000 per unit fee, what was that again?
That's a new bill, AB 712, that's on the governor's desk. And it says that essentially if a city was warned, received, I'm paraphrasing.
Yeah.
If a city was warned by either the Attorney General or HCD that, and took action in opposition to what they were told to do, basically, and lost the case, that they would be subject to, the court is required to impose a fine of 10,000 a unit.
Okay. And you're aware of what I perceive to be a pretty threatening letter from HCD? Have you seen that? It's public.
Yeah, I think it seemed to basically say, better do what we say.
Yeah. Okay.
Yeah.
Thank you so much.
Okay, and I'm going to move on because I think Councilmember Egger has questions. I did want to sort of note that the meeting is really about new housing laws and not specifically about School Street. I know everyone's dying to hear about that.
Yeah.
So,
Yes, and I
Mr.
don't really know details of that project.
Right, right. So Councilmember Egger.
Yes, Fairfax set up 13 sites for ministerial approvals. The other Ross Valley towns, San Anselmo, Ross, Larkspur, and Corte Madera, combined had nothing like that at all. They have not done that. We'll never have enough jobs here to fill all of the workforce housing overlay zone sites that we've established. If a fire happens in one of these housing towers, the Ross Valley Fire Department does not have a ladder truck sufficient to rescue people in a high-rise fire. They've said, well, we'll borrow one from Santa Fe, and Santa Fe will send one out to Fairfax. Santa Fe had a fire a month or so ago, a three-story complex down the canal, and 2 women died in that fire because they couldn't get them out. They couldn't save them in a 3-story fire with all of their ladder trucks at Santa Fe. What's going to happen in Fairfax if we've approved up to 7-story housing sites, housing towers, and a fire happens and we have to call on Santa Fe or Southern Marin to get a ladder truck up here and we can't get them out? Is it possible that we're going to be liable for wrongful death for approving a complex where we know we can't rescue people from that complex?
Maybe the city attorney would. This is not really my.
And I'm going to note the fire trucks in Kentfield, actually.
Yeah.
Thank you.
This, Frank, we can have this discussion later. This is a presentation on the housing element. And so.
Folks, can we settle down? Thank you. We'll
will
talk about
go
them later.
ahead and tell you generally no, liability is not going to attach to the town. But that was a generalized statement. That's not what this is about. So let's keep this to questions. And then when we end up, we can have council member
Folks, can you
comment.
please keep it down? If we don't keep it down, I'm going to call the meeting to a break. So if we don't keep it down, we're going to take a break. I'd like to hear the council members' questions right now. Okay, so we need to hear the council members' questions and the answers from the presentation, the presenter, and the staff. And so I think there's some other questions. I see both from Commissioner Bella, but I wasn't sure if Councilmember Kohler or Garangeli wanted something. I'm sorry, are you done? Got a little distracted there.
I just had that one quick question. I'm not done. No.
Okay, no, keep going if you have more questions. I didn't
I
want
don't
to.
want to.
Okay, I just have 2 questions. I sit on a legislative committee, and my recollection was a couple of years ago, there was a bill that was signed by the governor that allowed the attorney general to go for penalties higher than what there were. It used to be $10,000, I believe, a month or a day, and it went up to $50,000 for not having a certified housing element. Can you clarify what that is?
Yeah, those penalties only go into effect if you have a court order to adopt a housing element, and after a year you haven't done it. So.
And what are they? Because
They can be either, they start at 10,000 a month and they can go up to 50,000 a month.
Okay.
But again, that's only if you decide to ignore.
So if a housing element was decertified and the attorney general went to court, even though we had one, but it was decertified by the Housing and Community Development, potentially that's something that could occur by a court?
Only if the court told you to adopt, what to do and you ignored the court order.
Okay. And this was kind of my misunderstanding. You mentioned something that there's a difference between ministerial and by right. And I had always put those together. Could you explain the difference?
there's a lot of, so the ministerial approval provisions usually have very tight timelines. They say that, somebody can only approve it and so forth. The by right provisions only say that you can't require a discretionary approval. You can require design review approval if it's not a project. And you can't require review under the California Environmental Quality Act. So the language is considerably different than in the ministerial provisions. And it does allow for design review.
Okay, well, thank you. All right, I think
Can I
Councilmember
just
Egner had-
clarify that answer quickly? You mean it's not an affordable project?
It has to have 20% of
Okay,
the
you just
units
said it's not a
must be.
project, so I just wanted to make clear we're talking, it's not an affordable project.
I mean, it would be an affordable, it would, meet the standards of an affordable project also. But to say I'm entitled to by right approval, then first of all, it has to be one of these sites that was designated in the housing element, either for upzoning or what the planners call reused sites. So it has to meet that category. It has to be, the ordinance has to allow design review, and it has to be 20%. It has to be 20% affordable or to lower income.
Okay, and can you, Councilmember Garangoli has a question, and then we'll go back to Mr. Bell after
I
that.
do. I mean, I wanted to reserve most of my questions for after the public speaks, but this is bringing on some questions. I think September 3rd was our last council meeting. We adjourned with I think our next meeting is October 15th. Is that right? And we had no other planned meetings and until this one was added on. And so when were you asked to speak tonight at this meeting? When did someone call, who called you up and said, can you come and make a presentation? She can't answer that question?
Michael, Councilmember Garangeli, I asked her, okay, I
Okay.
called her.
Well,
and
that
asked her.
was my question to her, but
Yes.
Yeah. I
Okay.
will say that there was a community member who asked me to make a presentation, and I said, no, I didn't do that. I didn't want to make a presentation if I wasn't asked by the city.
okay. And by the way, I thought it was very informative. I think that a lot of this has been discussed before, but I thought your presentation was great. I also think that it leaves a lot more questions that need to be answered than even the ones you addressed, because it's such a can of worms what the state has done. And also, I would point out in my estimation that not every town has set their general plan up the way our town did. They have discretion, heights of buildings. Some are lower, some are higher in towns. Is that true?
Well, your
Well, as
ordinance,
well, I guess let me clarify. Just a two-story town. San Anselmo's are the town closest to us. And from what I understand, they have had some sort of height limits on their housing.
the city can.
So it's a discretionary thing is what I'm asking. That's okay. I know.
Well, the city can impose height limits, yes, but the developers can use density bonus law to have those limits waived. There's a community on the peninsula that had it's a dense community. They had 8-story height limit in the downtown, and a developer is proposing a 20-story building under density bonus. So
Like,
that's
can you go back to the density bonus slide, please?
Okay, and
Yeah.
let her continue her
that's
thought.
Well,
Let's
I'm thinking
let
it's
her
my turn.
continue her.
Yeah.
Okay, okay, I'm going to let you go on. I just wanted to let her continue what she was saying because everybody kind of jumped in and cut her off, and then we'll go back to your questions.
All I'm saying is that I think the ability to use density bonus waivers to exceed height limits is what most upsets local communities. But
The other question,
there are few limits. That's the problem.
okay, I have one more question. Because I noticed that a a lot of your, on the project review page, the safety standards seem to be a important way to battle this thing, all these 500 laws that the big guys up at the state are asking for. And we passed on a 3-2 vote. We passed the fire safety element. 2 of us voted against this, and 3 voted for the fire safety element, or the safety element, I should say. And that was one of the remedies, or one of the things that possibly could help slow things down or have them take a closer look, because in my estimation, there's nothing safe about what the state's asking us to do.
Despite the fact it's not in your safety element, unless it's contrary to something in your safety element, you can still adopt fire safety standards as an ordinance.
Thank you.
Okay.
Mayor?
Yes, sorry, I can't see you, so it's good. Thank you. Go ahead.
Sure. What's interesting is Fairfax adopted its housing element. It certified the programmatic EIR, and the EIR never really looked at the totality of what they approved or set up. I calculated all the potential in the workforce housing overlay zones A and B, all of the open space, both public and private, that's going to be developed, and other sites. And I come up with about 1,000 units that this general plan update and housing element is going to allow in Fairfax. As you pointed out, we need at least 490 for sure, and to plan for 588 is better. If we've planned for 1,000 and we only needed to plan for 490 or 588, could we go back and reopen and reduce some of these numbers?
Yes, it's possible to amend your housing element, but you know, I mean, you could try to present evidence to HCD about why, modifications to the housing element still meet state law. That's possible. HCD is very difficult to deal with, I think, as many of you may know, and they often will not allow, they often dump out sites there. Anyway, but if you can convince them, yes.
So what's really interesting is that one time the state attorney general's office defended Fairfax over the years in its zoning actions to protect this little town. And here we got the attorney general's office doing the exact opposite now, taking all these little towns up and down the coast down.
Thank you. So I had a couple, go ahead, Commissioner Bella.
So a follow-up on the risks to Fairfax from having a decertified housing element. You talked about attorney's fees, defense costs, this new law, AB 712, but what are some of the other risks? I think I heard anecdotally that if we have a decertified housing element, we might be ineligible for other types of grants to support, municipal investment, the public works infrastructure. Is that true that if you have a decertified element, you also may be at risk of losing other potential sources of state funding?
I understand that's the case, but I actually haven't looked at what state sources are affected. Because I think the builder's remedy is such a huge blow that people have been focusing on that. But I have seen, I guess I've seen letters from HCD saying that a certified housing element is required for certain funds.
Okay. I'm sorry. Okay, PJ.
Yeah. This one, hopefully quick, and then a second question. First, you mentioned in one case, Huntington Beach had an attorney's fee award against it of $3.5 million. So, you also mentioned high defense costs and that these YIMBY groups are very litigious and developers. In addition to the attorney's fees, is there like a ballpark of how much it costs for the town to have to defend these suits?
In the hundreds of thousands.
Okay. And that's like per case.
Yes.
Okay. And the towns have to post the bond to appeal.
To appeal, yes.
Okay. Is there any fee shifting the other way? Does the town have a?
You might wish. No, it's almost impossible for communities to collect attorney's fees. My only experience, let's say I've been an attorney now for 20 some years, was a developer accused the city of breaching a settlement agreement, and the city was successful in saying it had not breached the settlement agreement and it had an attorney's fees clause. So the city got a little money there.
Got it. Thank you. It's ridiculous. Other people can just decide to pile on costs onto a jurisdiction. It's
Yeah, they're really in a punishment mode, to be honest.
and then my other question is just so when discussing HCD's enforcement power, there's the whole enforcement process from notices of violations and technical letters and eventually referral, and decertifying your housing element. Can they require specific performance of anything in the housing element, like programs? Like, for example, we have an action plan that says there's going to be a geologic study of the town center area. Can they sue and say, hey, you haven't done this, you said you were going to do it?
Yeah, I mean, technically the statute gives them the ability to decertify a housing element if you haven't implemented any of the programs. Now, I've been told that their focus is on the rezonings and actual adoption of housing elements and not on the other, but yes.
Okay.
And it's not just that HCD can sue you, but some of these YIMBY groups can also sue you. And I've had a client, we defended somebody where the YIMBY groups were attacking them for not doing certain things, which did not have to do with rezonings within the time limit.
So just to be clear, it's the way that would happen in practice is they would just decertify the housing element until you adopt whatever program they want you to adopt?
It kind of depends. I think they don't seem actually eager to decertify people or leap in. I mean, there was the case of Portola Valley where they decertified their housing element without any warning, and they actually don't. If you look, they have to give you a warning of up to 30 days, but they don't have to give you 30 days warning. That's an extreme case. I would say with most of the others, one of my clients just got a letter saying, hey, we finally approved your housing element. Why is it taking you so long to adopt it? Generally, if you say, hey, we're going to do it, here's our schedule, they won't go after you.
And last,
I mean, that's just a practice, though.
And last follow-up. So I know that a lot of the focus in our housing element process was on choosing the sites and allocating amounts. Is that the bulk of the litigation also about housing elements, the disagreements between HCD and towns versus we say we can allocate 30 sites to 30 units to the site, and they say, no, you can only use 10 at another?
Ironically, I'm not aware right now of litigation where HCD has said, we don't agree with how you've allocated the sites, but the city says, hey, I think our sites are adequate. The cities have generally done everything they could to get their housing elements approved, and it's been I'm just not aware. On the other hand, 3 of our clients were sued by one of the YIMBY groups who didn't agree, even though HCD had approved their housing element, they were sued anyway because the YIMBY groups didn't think the sites were adequate.
Did they win?
I think one's in court, and I'm not quite sure what the status of that is. The other 2 settled.
But the town is still incurring legal fees fighting these, whether or not they win or lose, right? Okay,
Yeah.
sorry. So yes, are you done? Yes. Okay, so Councilmember Garanghelli.
Okay, I think one of our biggest responsibilities to our communities is the safety. We owe a safe environment to our citizens. And you had mentioned earlier, and thought it was a good thing that you had mentioned it, that infrastructure needs and things like water are, reasons to consider, additional housing or not. And I'm sure everyone in this room is aware of it, but we have been short of water many times in our history of this county. And in the 70s was the first one I can remember. We used to call them droughts. I'm not sure what they call them anymore. They probably changed the name. But so there was a serious water shortage in this county prior to any increase in more usage. What's your opinion on that situation?
I think you would need to have some support from Marin Municipal Water District. Is that who serves Fairfax? That, that there's inadequate water. Now, the communities in Monterey County are under a state water board order saying that saying that there's not enough water and they can't, for people to build anything in Monterey, they have to, either install a lot of low flow toilets or somehow get some kind of a water credit. So, but Marin's not under that. So I think there would need to be some kind of a finding from probably MMWD. Yeah.
Okay, so are there any other questions? Okay, one more from Commissioner Bell.
Okay, one more over here. So you had mentioned that despite all the work the state in the last number of years passing all these housing laws, not a lot of housing is actually getting built. But are there any cases that you're aware of, any communities in California that have either met or even exceeded their RENA allocation numbers? Are there any communities that you're aware of that are actually succeeding in sort of accomplishing what the state is hoping to do with the passing all these laws?
I'm not aware of any right now. The state in the Bay Area, the state's supposed to look at how you're doing halfway through, so they'll take that look, I guess maybe in a year or two, and you can see if people are keeping up. The difficulty is that the statewide RENA requires construction of about 315,000 units a year, and the state really hasn't exceeded 125,000 units a year. So for any community to meet or beat its allocation would be pretty unusual.
Okay, so, and are you able to stay?
Oh, yeah.
Yeah, okay, great. Thank you, because that would be lovely to be able to call on you after we hear from the public. So at this point, I'd like to open it up for public comment. And we'll go for 2 minutes a person. And please line up. And what I think I'm going to do at this point, can you give me an idea if there are people online, Town Clerk?
Right now we have 3 speakers on Zoom.
Okay, so I think unless we get a whole lot more, let's go for at least 30 minutes and I'll check with you again on how many people are online and we'll see how much time we need. So let's go ahead and let's start out with Mr. Salen.
I'm speaking specifically about School Street and large buildings in Fairfax. And this is all about profit for the builder. This is not about affordable housing. Pretty much nobody that actually works in Fairfax makes over $50,000 a year. This building is not serving Fairfax. It is not serving local. We don't have the water. We have failing infrastructure. Our roads are a mess. We don't have very good transit except for maybe, the middle of the day and try getting to San Rafael or try getting to the city and transit from here. Personally, I want you guys to repeat after me, everybody. I will not allow this building to get built as it is.
Thank you.
I will not allow this building to be built. This building is gross. It just is. Let me finish, Liesl. Don't interrupt me. The building is toxic materials. It's not being built well. It's going to off-gas all kinds of crap. We need housing, but why don't we actually do real affordable housing and actually take care of people? Yeah, there's people that make $120,000 in Marin, but there are very few of them working in Fairfax. We're not serving our community. Be clear, this is profit for the builders. We need to change the laws. I will not allow this building to be built, and I want everybody in this town to say that with me and agree and make it not happen. Thank you.
Madam Mayor, Madam
Hi,
Mayor.
thanks. Can we not yell in the audience? We're going to move on to the next speaker, please. Thank you so much,
Set the timer.
Mr. Stalin.
Madam Mayor.
He has a little bit
Say-
of time left. He has a little bit of time left.
We're not powerless. We are not powerless. We can stop this and we will stop this. We don't need builders making a bunch of profit. We need actual housing.
Thank you. So,
We need
Mr.
healthy environments and we need to deal with our human
Mayor.
population.
Thank you. So I'm going
Madam
to stop
Mayor.
for just a second. Yes, Town Attorney.
This is not about any specific project, and we must keep the comments off of specific projects.
Okay, thank you. So I'm being reminded that basically the Brown Act says that we have to talk about only what's on the agenda, and School Street is not on the agenda. What's on the agenda is new housing laws. So we have to also enforce that on the comments. So sorry, folks. So go ahead, sir.
Hi, thank you. I just wanted a little more clarification on the exemption of CEQA. So it's not clear to me. It apparently some projects can go exempt from CEQA. Exactly how does that happen? And especially on a high density project, how do these developers avoid CEQA? Can we get a little more clarification on that?
Yeah, so I'm going to, I think we're holding questions to the end, right? So I'm going to write them down, and if I wouldn't mind if other people would help me. So your question is, how do they avoid CEQA?
Yes. How does a developer
Bypass.
avoid CEQA? Because I mean, we have this bit of legislation coming down from California that's requiring all these mandates, and it's in direct conflict with another bit of legislation, CEQA. So I would like more clarification on how does a developer avoid CEQA exactly, like specifically in Fairfax. I would like to know how that is. And another question I had was, has there been any local municipality that's challenging these state mandates? Have any of them challenged jurisdiction? I would like to know the answer to that also. So.
I'm sorry, you're saying local, right? Or do you need
Yes, well,
statewide?
apparently there are many small municipalities around California who are trying to challenge this housing act, this Orwellian housing act, and I just want to know of the many objections that are currently in the court system right now who are challenging this act. Have any of them challenged jurisdiction? Have any of them sued for jurisdiction? That means, have the municipality sued the state of California for jurisdiction? That's just one question, simple question I have. So, yeah. Can that be answered right now, by the way?
I don't know. We have to wait till the end, but I'm writing them
Yeah,
down because I'm
oh.
going to run through the list at the end of this.
Okay, all right, thank you.
Thank you so much.
Madam Mayor,
Yes.
if I may.
Yes.
So we're trying to bring up the timer as we normally do on the screen, but it's not working right now. So please bear with us. We will, let you know when there's time. And then just a reminder for everyone who may or may not be familiar with this process. The public comment is comment, and there cannot in this forum be like an interchange between the participants. The mayor and other council members may, take down the questions and choose whether or not they pose those questions. But this process is controlled by the Brown Act, and there isn't that interchange.
Thank you. And I'm saying I'm very committed to getting the questions answered. So I'm going to write them down, and I'm hoping other council members are also doing this to make sure that we get all of them. So yes, Mr. Reed.
Yeah, hi, John Reed from Fairfax. And yeah, greetings to the Planning Commission and the council. I guess a lot of people are concerned about School Street because it's an example of how this has played out, and we'll see this play out a number of times. I guess my big concern is, or one of my many concerns, is that a lot of concessions and waivers and density bonuses have been allowed in that particular case, which, you know, has resulted in the height that is a problem for so many people. You know, and I've heard council members in the press express surprise that, you know, it kept on escalating so much. But my understanding is the way that at least the initial housing element was written, it allowed all of these concessions and waivers and not builders remedies, but the density bonuses to be stacked upon each other. So, you know, the project kept on coming back with more and more higher numbers each time, and of course a higher building at the same time. And I think that's a very big problem. And I think that rather than express surprise each time it comes around to another place and you get another 7-story building, the thing to do is to really close that loophole. So, you know, a builder doesn't come back again and again and keep on making it denser and denser. And it's going to happen every time. I mean, in this case of School Street, the owner wants a huge amount of money for that property. And the only way a builder can make that work, even pencil out, is to build this huge building, which they, you know, basically all these stacking up of the concessions and waivers and density bonus on top of each other enables that price to be sky high. And the only thing that pencils out is a 7-story building. You know, the builder's pretty clear on that. And I think his margin isn't that big. It's really determined by that big price being asked. So I think that's a good thing to address. And that will
Thank
keep
you so much.
everything down. Thank you.
Great. Ms. Carson?
Joe Carson, Scenic Road, Fairfax. Oh, sorry. Joe Carson, Fairfax, Scenic Road. This is about mostly HCD, but it's real relevant. Question, are there decision-making individuals that we could identify and influence, or is there a public access to the decision-making process regarding the definitions of low income and very low income? And is it in any way possible to bend the levers of power so that we can get a Fairfax-specific definition of low income and very low income? I found out, to much my chagrin, that I qualify not actually enough for even very low income. I was surprised. I'm a registered nurse. I've been happily employed. I thought I was doing quite well, and I was shocked to discover that I'm below very low income in Marin County, probably not in Fairfax. Thank you.
Thank you. Next, please.
Hi, I'm Shelby Lamont. I live on Manor Road in Fairfax. I was a member of the Planning Commission for many, many years.
Speak closer to the mic, Shelby, please.
I was a member of the Fairfax Planning Commission for many years, worked with several of you guys on this, and want to thank you very much for the presentation today. That was really helpful. I think, Mike, you make a good point about safety in Fairfax, and I would task the council to look at what these standards are to increase our objective standards with really tight language, really specific language that the Planning Commission and the Town Council can stand behind. But that's one very, very small measure against a large state. And so I think Barbara made a really good point about saying you need to talk to your legislators. These are people making this law, and this is the language that they're giving us. And if we don't like it, that's where we go to change what's happening in Fairfax. It's the state coming down and saying that this is what the state wants, regardless of how amazing Fairfax is. So it's easy to bludgeon our town council. It's easy to bludgeon each other, but it's the state that's making these laws, and those are the people that we need to talk to. And if we need to go to the Capitol and start making trips and saying our say and saying this is You know, this is a giant sledgehammer being used on a tiny little finish nail, and we need to fix that. And so we need to work within the system. And, you know, yes, we need objective standards, but it's bigger than that. And so I just want to thank you all for doing everything that you do. It's a lot of homework and it's a lot of understanding laws, and it's an amazing job that you're all doing. And it's not our council that makes these laws. So keep it in mind. Thank you.
Thank you. Next speaker, please.
Miriam Weinstein, Fairfax, and I would like to note that Kentfield's a lot closer than Sacramento, and we all know who lives in Kentfield. I'm wondering if we don't meet the numbers because they don't pencil out, not because of Fairfax's action, but because Trump just raised the tariffs on kitchen cabinets and there's less low-income labor available, although they probably require union labor, I don't know. So like if they say we've got to build these numbers and we approve them and they don't get built, can they still come in with builder's remedy? Are they? Yes, they are that nasty. And because I know a lot of spots that we approved have already been taken out. There are already other uses. And there was one action in Lake County where they, I think around Lake Canocti, Mount Canocti, where they wanted to put in a big resort, and environmental groups sued, not the town. And they said the evacuation danger for the current residents is too high, and they won. So I keep wondering if it's not the town that does the objection, if it's private citizens, is that a little bit better in terms of the state coming down on us? Although I gather they feel Lou Tremaine's as guilty as the town with his lawsuit. That's my questions. Thank you.
Great. Thank you. Next, please.
Valerie Hood, Fairfax resident. I just did a little basic math. 13,000 people in San Anselmo, around 8,000 in Fairfax, that's 21,000. 60,000 in San Rafael, that's 81,000. Maybe 5,000 or more in San Geronimo Valley, that's 86,000 people. What if we had a fire during an event in our town where we bring in 20,000 people or so? That could happen. You trying to tell me that somehow we're going to be able to evacuate our current number of people, of 86,000 people, out to 101 if there's a firestorm? Because people are going to panic. We all watched what happened in Santa Rosa. Those people were close to the freeway, and look what happened to them. We're not close to the freeway anymore because it is gridlock, traffic here, many more than one time a day. On the weekends, it's ridiculous. We have no way out. And burning in place is not something I think about wanting to do. I don't think anybody in this room does. This has nothing to do with affordable housing. This is making our lives extremely dangerous. I just found out from walking door to door in my neighborhood that most people in my neighborhood had no idea that there are 2 7-story buildings being considered, which will block our sunlight, which will be unbelievable amount of construction noise, not to mention the Fairfax Laundry, which is should be a hazard site. You know that it's full of chemicals, and those being unleashed in our neighborhood will poison our neighborhood. And I've been very diligent in telling people about that. By the way, signature gathering is going very well for the recall.
Thank you so much. Take care. Ms. Neil Ricker.
Good evening, Candace Neil Ricker, born and raised Fairfaxian resident, one of your ultra low income Fairfax residents that would not work multiple jobs to be here to take care of my mom. I am that person that will not be able to afford to rent at School Street. Whatever your intentions for workforce housing overlay for your people that need ultra low income housing, that was not it. That was a sell down the river to the developers with carte blanche on a silver platter. As someone that works in town, you add 500 to 700 cars to this town parking and fighting for parking daily throughout residential areas. Not only will you have mass issues between people, but these businesses will fail. There's already inadequate handicap parking for our aging seniors in this town. 1.24 million in housing consultant costs. That I can hold on the council. Not the state mandates or what they're requiring, but the misuse of funds and mismanagement of time. And I ask the Planning Commission to consider that as well. I feel sold down the river. I would ask Mayor Blash to consider her background with MEHC, Marin Environmental Housing Collaborative, and her work at Victory Village, and what was sold to the town there and purported to be, and then what came from it. I believe now is the time that Fairfax needs to fight. Fairfax has fought many times over its history for many things. It's always been a wild card. Look, the county supervisors won't even come near us. There's a reason for that, because we are a wild card. Every council in Northern California is watching us right now to stand to the state, to recognize fire safety issues and dangers. We can amend our housing element, if I understood that correctly. San Anselmo kept their 28-foot height restrictions. It could be done here.
Thank you. Next, please. And hi, we're going to hold off clapping so that we can make sure that everybody feels comfortable speaking. So next, please.
Good evening, Council. Sean Fitzgerald, Fairfax Park. One of my favorite visuals and just kind of sayings is that if you take red ants and black ants and you put them in a jar, they more or less will leave one another alone. But if you shake that jar, they start attacking one another. And to me, the housing crisis is that shake of the jar. It's manufactured. I've been in affordable housing for the last 7 years doing low income, entirely minority, and mostly women and business-owned home ownership lending. And I can tell you that there's not a housing crisis in California. There's 140,000 available apartments right now on apartments.com. That doesn't even count homes that are for rent. The population has been declining in California for the last 5 years. We've had a net loss of 250,000. Marin County has dropped 7,700 residents in the last 5 years. We have an aging population. And in California, the net birth rate, live birth per woman, is 1.48. We're not even at replacement rate in California. The population growth has been coming from immigration alone, and they can't afford brand new housing. Look at San Diego for an example of what happens when you overbuild on housing mandates. They have literally thousands of unrented brand new units in high rises. San Diego is completely fallen. I went to school down there. The reality is, affordable housing for workforce is needed where there are jobs. There is no industry here. Most of the workers make minimum wage. They're retail or they're service. They won't be able to afford the units built there. And what I've heard from this amazing presenter today is that we could have set a height limit of 4 stories or whatever it is for our town. And it could have met the RENA numbers because we've got 1,000 potential to be built. So it could have been half the stories and we could have got 500 units. Sounds like 25% could have been from ADUs because that's been successful in California. So we could have reduced the height and density. But the question I'd love for you to pose to this expert today is that why do we need to create a plan that has the RENA numbers met if a builder can then just come in and exceed them? That doesn't seem to make sense to me.
Thank you. Okay, folks, if we need to keep it quiet. Mr. McIntosh, please go
Thank
ahead.
you. A couple of clarifications. One, the choices where the town council allotted the required RENA numbers makes it a subjective choice. Therefore, to Mr. Egger's question, yes, the town will be liable should we be sued because someone cannot escape. It was a subjective choice where. Two, if you recall the first meeting in January, it might have been January 9th, our housing element consultant, Andrew Hill, specifically stood up here and tried to convince the town that by putting 243 units at the School Street Plaza, that they no longer do a traffic impact study where they count vehicles. They look at it holistically with vehicles, miles traveled. And he had the audacity to try to tell you, so you would pass your safety circulation for the housing element, that it would reduce our pre-existing traffic congestion by 15%. Before 2021, the Marin County average household generated 11.7 car trips per day. Therefore, you should assume School Street Plaza will bring in an average of 2,400 new car trips per day. So add that to the equation of our escape routes. But more specifically, to a comment that our very nice presentation made today, there is a secret provision that the municipality has to negotiate in good faith with any developer that brings forth affordable housing within a mandate. And this was further codified in AB 130. The specific secret provision is 210.80.66. And that basically is telling you that when we build all this affordable housing, that profit's going to the developer. And then we, the town, have provide the taxes and the bonds to provide the infrastructure for the success of that project. So these all have a big impact on our town. And the fact that the town, again, was subjective,
Thank
it's
you.
our liability.
Thank you so much. Okay, next, please.
Hey there, I'm Mark Fiore from Fairfax. Tough acts to follow here. I wanted to thank you, Barbara, for your presentation. And you said one thing in your presentation about, at one point, talking about the court cases that were going on. And you mentioned the pro-housing side is winning a lot of cases. And I just wanted to take this time to weigh in, in case there's anybody from the media watching this or something, that this is not anti-housing versus pro-housing. And I'm not going to speak for Fairfax, but personally, I am pro-housing as well, but I'm not pro two-story parking garage plus. And additional to that, extra retail that we don't need right now. So I don't think it's quite as simple as pro-housing and anti-housing. And if we need a good housing project, let's make it, but ideally not with a Boca Raton developer, worth $10 billion. So one thing that you said as well, Barbara, that gave me hope, and I hope I'm hearing this right. You said in reference to that San Mateo case, you said that I believe the court said that there was imposing a condition of approval rather than outright denial of a project. And so to me, I'm hoping, I don't want to violate the Brown Act, but that would be my question. Can we do something with that rather than just saying thumbs up or thumbs down? Hey, what about putting the parking garages underground? And yeah, we're all for density, but let's not have something that is a ridiculous, dorm on top of a two-story parking garage. Thanks a lot.
Thank you. Next, please.
Good evening, Todd Greenberg, downtown Fairfax. My questions are for the presenter, Barbara Couts. Thank you for your presentation. You're knowledgeable. Some things are left unanswered, though. Will any of the housing being mandated in Fairfax, whether it be School Street Plaza or elsewhere, provide for the average non-governmental employee in Fairfax that earns $51,000 a year, or the average service worker in Fairfax that earns between $37,000 and $43,000? If not, why should it be built? What about the second question? What about over the 100 cities that don't have a certified housing element? Are they going to be extorted by this state's HCD out of existence? The votes made by Kohler, Hellman, and Blash that have created the large unfunded mandates that will cost Fairfax far more than the threatened penalties from the state, given that Fairfax already has the highest taxes in Marin County, who will pay for these costs? Who is liable? At what point is it malfeasance or misfeasance? And then finally, for sake of clarity, your law firm, Goldfarb and Lipman, which has done extensive prior work for EAH Housing, which is a fiscal sponsor of MEHC, where Mayor Liesl Blasch was the housing specialist for over 6 years. Given the work done for developers, I question if this is a fair presentation and whether there are conflicts of interest. Please clarify. Thank you.
Great, thank you. Next speaker, please.
Deb London. I wasn't going to talk, but some of the speakers previous to me were amazing. Candace, Sean, Todd, so many of you, Mike, Mack. There is no need for workforce overlay. Like it is a fact that we have no industry, like they said. We don't need this. And honestly, I'm kind of tired of everyone scurrying around the minute they hear from the state of California. And I think that quite a while ago, we should have stood up. We should have dug in. We should have said no, like some of these cities are doing now. And I applaud them. Coronado, Huntington Beach. I would love to see some of these small towns form a union. We just stand together and we say no to the state of California. And I, for one, hope at some point, before it's too late, and all these beautiful little towns have been destroyed by this housing that we need. We need to go back to this School Street Plaza, and we need to change these numbers. I mean, 13 locations when some of these other towns, had 1 or 2? It reeks of the overzealousness, the same as the paralyzing rent control you guys put down. Let's do 13 locations. Everyone else only has maybe 1 or 2 or 3, but damn it, we're going to do 13 7-story high-rise locations. I just think it's disgusting. I think we need to go back. I think we need to dig in. We need to say no. We need to stand up. That's all I have to say.
Thank you. Okay, next speaker. Is there another speaker in the room that would like to speak? Thank you.
Hi, I'm Jenny Schmidt. I live for 30 years on Iron Springs Road. And what I want to say is that thank you, Barbara, for your amazing presentation. It was not just nice, but it was actually very educational because I'm not a lawyer and I don't play one at town council meetings. Thank you, Planning Commission, for all your hard and thankless work. And thank you, Town Council, for your hard work. I agree that we have evacuation danger. I agree with Valerie Hood's comment about evacuation danger. But I don't think that you guys are the right people to address. And I think Barbara helped us see who we should be talking to and what we should be doing to our housing element in order to closely examine if we're allowed to retroactively put things in there. We need to make some changes. So like that's what you guys do. I agree with Sierra. He doesn't want the building. I want some housing. We need housing. Housing is good, but like Mark said, we don't necessarily need a layer on top of a layer on top of a layer, but infill housing is better than building on our ridges. But I don't think that like chaining ourselves to fences is going to stop the building. What will stop the building? Nothing, actually. But what might mitigate its impact is not yelling at town council, not splitting the town apart, but focusing together on ways to tweak our safety element and try to get some numbers out that will make it clear that we can't tolerate all that.
Okay, thank you. Are there people online at this point?
Yes, Mayor, there are 3 speakers online.
Great.
The first
I thought you were
speaker,
gonna go.
okay, we're ready for them. The first speaker is Jane, followed by Kay. Jane, you are unmuted. You may unmute yourself.
Hello, thank you. Can you hear me?
Yes.
Good.
Yes, we can.
First of all, I cannot help but wonder, why now? Why didn't you reach out to the community in the beginning when we could have added our thoughts? If you were interested, we could have all helped. We could have helped to find a way to fight this instead of now when the hour is late and now we do this. I cannot wrap my mind around that. I don't know, how did this happen? Why did this happen? Why wasn't something done to protest in the very beginning? It cannot be that we have no rights, no voice, no power, no nothing to stop this abomination, which is very clear to absolutely everybody. It's nothing but a power grab for the developers. There is no affordable housing here. This is a big joke. It's the wolf in sheep's clothing trotted out by Sacramento. I say, why don't we join hands with all the other towns? None of Marin likes this. Probably none of California. Why can't we get together? March on San Francisco, march on Sacramento, march on Kentfield, march on everybody and anybody and everywhere we can. We simply cannot allow this to happen. It will be the absolute ruination of Fairfax. It will be a black mark, I'm sorry, but on all the town council that allowed this to happen. You could have reached out to us earlier. It's a little late to do it, but it's not too late. Everybody is united in the fact that we will not have this. We will not allow this monstrosity to destroy our town. Not just this one, but all the others that are going to be coming up around. It would be the end of Fairfax. Can you really imagine what our town would look like with this behemoths all over everywhere? There are photographs on next.
Thank
Look
you.
at it.
Thank you. Next speaker, please.
The next speaker is Cindy. You are unmuted. You may unmute yourself.
Hello? Yeah.
Yeah.
Oh, I wasn't sure if you could hear me. I'm sorry. Anyway, this is Cindy Ross. And unfortunately, I was a little bit late to the meeting. So I don't know if this was covered, but I know when I first came in, there was talk about what's going on in San Mateo and also some mention of what's going on in Huntington Beach. And I'm really puzzled by that. You know, Fairfax is a little town that's 2 miles. And, San Mateo is a 15 square mile city with 103,000 people. Huntington Beach is 35 miles with almost 200,000 people. And I'm just wondering, where is the comparison? Why are we talking about a little town that, why? Even if there are housing mandates and even if we need to put in housing, why are we talking about putting the equivalent of 186 of my house in a 2-acre little tiny piece of property and, in a small town that doesn't have the infrastructure to support that? As other people have said, we have 2 roads out. If we had to evacuate, there's no way that we could get out safely if there was a fire or an earthquake or something like that. And, as somebody else mentioned, if we're talking about something like School Street Plaza, I know we're not supposed to talk about specifics, but that's the one that's the most, imminent. They're talking about retail space. What that has nothing to do with housing. So how are they able to get away with pretending that they have, all these options to do even more, you know, on top of retail space? That has nothing to do with housing. And
Thank you.
one more.
I think, Cindy, that was time. Is that correct? So I've got your questions, and they're good questions. And so I think we'll need to move on to the next speaker.
The next speaker is Kay, followed by Kevin. Kay, you are unmuted.
Hi, thank you. Thank you, Ms. Couts. I hope I pronounce your name right. I'm actually specifically asking you my question. You did mention specific adverse impacts, and I'm a registered nurse with a public health license. I want you to be aware we are unique. A third of Fairfax population is over 65. We have no accessibility to downtown. We cannot walk, and public transportation is not virtually non-existent. In 2023, the Surgeon General declared social senior isolation as an epidemic, costing an estimated $6.7 billion in excess Medi-Cal spending annually, largely due to increase in hospital and facility trending. They found the main pillar to strengthen this was design environments to promote social connection in local communities. I have a big Surgeon General report I can send you with all the research. I think this is an avenue we might be able to go down, the only one I can see that we could. Also, I would love to get clarification because it's very confusing versus what the state mandated versus what our town allowed. So can I get clarification between the density units per acre the town decided versus what the state required? The presentation, page 2 of the RENA numbers, shows that the town chose to put all the required market rate requirements into one lot, 175 units out of the 184 required, which was a zoning of 92 units per acre.
Thank you. Can I get the next speaker, please?
The next speaker is Kevin. You may unmute yourself, followed by Zoom user next.
Good evening, commissioners and town council members. I thought you might all be up there on the dais, squeezed together in a boy-girl fashion. My comment tonight, I'm from outside of Fairfax, is regarding in my mind, most important thing that you can do to make a huge difference in the housing element density coming your way as early as the next meeting, and that is regarding the workforce housing overlay local affordability density bonus. And you could suspend that. And the reason why, and this is where I would like Barbara, Ms. Couts, to go ahead and jump in on this and explain it, is that the local density bonus laws have changed, which is if there is a way for the maximum density to change within the local objective standards, then the state density bonus on top of that is calculated on the maximum density available within the objective standards for, in this case, the workforce housing overlay, meaning that on a 1 acre parcel, if it is zoned for 20 units, then the local density, if that is enacted, could go up to, say, 40 units. At that point, then the developer double dips and gets 100% to 80 units. So that is what has happened on some of these sites. That's what you can change. Andrew Hill had mentioned that this is a mirroring of the state density bonus and that the intent was an either or for developers to choose either or. Right now, what is happening is that they're double dipping. So that's what I would recommend. And I know it would be something that would greatly benefit a lot of the residents in Fairfax. And it looks like you're going to make great progress on meeting some of your goals here real soon. Thanks.
Thank you. Next speaker, please.
Zoom user, you are unmuted. You may unmute yourself. You will be followed by Liz, and there will be no more speakers after that on Zoom.
Hey there, I live, can you hear me? Can you hear me?
Yes, we can hear you.
Hi. I live in an area that will be affected by one of the proposed developments. And I'm sorry if this has been covered before, but my question is about sunlight. I and several of the neighbors on my street have purchased solar. And I'm wondering if we have any solar access laws or right to receive sunlight or not have your sunlight blocked by a neighbor, because a building of this height will in fact impact our ability to collect and use solar on our property. And that's my question.
Thank you.
Mm-hmm.
Is that it?
Yep.
Okay, great. We got that. And then there's one more.
Liz F., you are unmuted. You may unmute yourself.
Hi, can you hear me?
Yes, we can. Yes, we can
Thanks.
hear you.
Thank you. Liz Frauenberger. I have a question about something that Barbara, and I'm sorry, I didn't get your last name. I came in a little bit late, but thank you for the presentation. But Barbara, you had said something about the fact that there would only be 5 public meetings allowed to discuss a particular project when it got to a certain point. And I tuned in late, so maybe you meant that after it was approved, there could only be 5 of these meetings. But then the thing that really caught my ear was that the developers could use up a meeting by just simply calling for a continuance. And that confused me, because if I were a developer and I didn't want the public to speak, I would just keep using that time to call for continuances. So I must have misunderstood, and I'm hoping to understand that. So maybe when the time comes, that question could be answered. And I'm sorry if I misunderstood. Thank you. That's all.
Great, thank you. Is that it?
Yes, Mayor, that's the last speaker.
Okay, so I want to bring it back, and I want to start out with the questions from the, excuse me, I was trying to time it and it just won't go to quiet mode. So anyway, I'd like to bring it back and have you answer some questions from the public. And I don't know if you were able to get all of those questions, or if you want me to read them to you.
Do you want me to go down the list I have?
Sure. And then if we catch something that you didn't catch, I hope it's
Yes.
okay if we interject. Okay, thank you.
So the first question is, how does a developer get an exemption from CEQA, from the California Environmental Quality Act? There's a couple ways, maybe the staff wants to jump in. There's a couple ways to do it. Usually, first of all, a developer is entitled to an exemption if they meet the requirements. The town can't say, well, yes, you meet the requirements, but we're not going to give you the exemption. So the developer is entitled to it. Usually, city staff looks through the application and sees if the developer qualifies for the exemption. The state changed the rules somewhat, where if a city determines that a developer say, hey, we don't think you qualify for this exemption, the developer can provide their own evidence. And if the city or town still doesn't agree they are eligible for the exemption, then the developer can sue the city. So they've tried to put some of this determination in the hands of the developers. But generally when an application comes in, staff looks through the guidelines, or the developer will, in a rather informal way say, hey, I think I qualify for X exemption. And
But
that's
what are
usually how
those
it's-
qualifications? Like what?
Oh, there's many. The 2 big ones, there's the new one, I call the AB 130 infill exemption, the one that was just passed. There's an older infill exemption. I'm just talking about some of the more common ones. There's also provisions that aren't exactly exemptions, but where you can rely on an existing EIR. There's dozens of exemptions. Then there was a question about whether someone had challenged the jurisdiction. Now, jurisdiction usually means the right to hear the case. And I'm not aware of any actual challenges to the jurisdiction of the courts.
I think the question was dealing with have people challenged the jurisdiction of the state.
Yeah,
I mean, I think there have been those.
Right. The Huntington Beach case that Councilmember Ayers referred to, it basically has to do, the federal case, with the state's ability to require cities to adopt a housing element and follow other laws. Has anybody sued the state? One of my clients did, actually.
But it was very complicated, and it kind of, the state, as a condition of their housing element, required that this community undertake a legal action to get rid of their voter adopted initiative. And so the city sued the state. Anyway, the court decided that no, the voter adopted initiative stayed. There's a couple of groups that are, this is not quite answering the question, but there's a couple of groups that are trying to organize communities. One's called Livable California. Another's called Our Neighborhood Voices. I'm not super familiar with either, but there are some efforts. One issue, another question was whether the housing element had allowed all the waivers and concessions and everything, and whether the city should close that loophole. No, the waivers and concessions are required by the statute. They're not, whether or not the town has anything in its housing element at all about it, the statute requires that the town grant density bonuses, waivers, and concessions. In terms of the definitions of very low income and low income for Fairfax, I've only seen tables organized by counties. I haven't seen them organized by cities. And to be honest, I don't know who actually makes those decisions at HCD. There are some very weird tables. If you look through their tables, I was looking through a table for Santa Cruz County. I was looking through a table for Santa Cruz County, and in that county, the low income figure is higher than the median, a lot higher than the median income figure. And the median income figure is close to very low income, which is supposed to be at 50% of median. So I have no idea how HCD develops the numbers. There was a question about if the town doesn't issue permits or approve 490 units, what happens? The town's obligation is only to zone appropriately. The town's obligation is not to make sure all the units get built. There is one, penalty, which there's a streamlined ministerial approval called SB 35. And if the units aren't built, then a developer could come in and use SB 35, which is a ministerial process, to build the units. There are some disadvantage incentives to using it because the developer is required to pay prevailing wage, which might increase their costs.
Barbara, just one thing on top of that. I thought that was one of the reasons why we were required to provide a buffer on top of the number, because the idea is we have to report to HCD every year where we are, and then at the midstream, they will look at us. Is that correct?
Yeah, a number of people have asked me recently about a midstream look, and the only midstream look I'm aware of is just looks at building permits versus RENA and decides whether you're eligible for SB 35. So I'm not, people have been asking me about it, so I've been wondering if it's a new thing, but I haven't heard of anything.
I'm just going to also add that the person asked if we were going to get builder's remedy if we weren't able to make the numbers by the end of our cycle.
No.
Thank you.
Builder's remedy is only if your housing element hasn't been approved by HCD. Yeah.
Or is decertified.
Yeah.
Right. Okay. Thank you.
Yeah. Right now, that's the only situation in which it shows up. There was a question about private citizens' lawsuits regarding CEQA and evacuation. I'm somewhat familiar with the Lake County lawsuit that was mentioned. I think, in fact, that was one where the Attorney General might have joined in the litigation. But yes, citizens can sue, but the project has to be subject to the California Environmental Quality Act before you can sue based on that. Of course, there could be a lawsuit saying it wasn't eligible for an exemption, although those are much harder to win. But yes, I mean, a private citizen's lawsuit is possible if the project is subject to the act in the first place. There was a question about why more accessory dwelling units weren't in the housing element. Remember, 20 or 25% of housing constructed in the state or building permits issued were for ADUs, but the state is nowhere near meeting the RENA levels. About a third of the number of units that cities had to plan for are actually being built. But in any case, HCD looks at what the city's history has been for issuing ADUs, and they're very, I have no idea about what the numbers were for Fairfax, but if you try to claim a lot more ADUs than you have a history of building, then they're likely not to approve it.
Yeah, so Barbara,
Yeah.
I was part of the housing element subcommittee, and it was based on our history of what we made, and there was a specific formula that we were allowed, and I believe our number was 80, which was the max that we could apply. So we couldn't say 490 ADUs. It was specific based on their guidance. That's correct, Jeff?
Yeah.
Thank you. Okay.
Yeah. Why can builders exceed the number of units that the housing element designates? Because of density bonus law, basically. I've got a client in San Diego County where virtually every developer has gotten a 35 to 50% density bonus. They're way over their RENA. Oh, there was an earlier question somebody asked about no net loss, about the buffer. Sorry, I didn't answer that. So the town assumed that a certain number of affordable units would be constructed on each of the sites that you designated. And if a developer comes in and doesn't build that number of affordable units, then you have to show that the inventory is still adequate to meet your allocation for that income level. So let's say the city assumed that on one of the affordable sites, there'd be 100 units and 40 units would be affordable to low-income households, but only 20 low-income units are built there. Then the city would need to show that it still has enough sites to accommodate those 20 units that didn't get built. I guess that's the easiest way. Let's see. Somebody mentioned Public Resources Code section 21080.66. That's the new infill exemption I talked about being adopted as part of AB 130. Let's see. There was a question about the fact that the housing wasn't being built for those making 31 to 51,000 a year. That's a problem. I've looked at what are supposedly low-income rents, and they're pretty high. I mean, okay, I've owned my house and our mortgage for a long, long time, but they're higher rents than I'm paying, for my single-family home. But that's,
is there recourse there?
I don't know of any recourse there. Yeah.
I think those are.
I mean, it's the HCD numbers. That was the earlier question about what can we do? The numbers are too high.
And I think they're set by HUD and then adjusted regionally, but I don't understand because I've seen some of the same anomalies you mentioned.
Yeah. Yeah, they're very odd. There was a mention of 100 cities without approved housing elements. I don't really know what the number is. Who will pay for the costs of litigation? I think that's the question. Well, the town, essentially. There was a question about conflicts of interest. Yes, a number of my partners represent affordable housing developers. My own background is that I worked for local government as a planner for about 30 years, and then I changed careers. My clients are pretty much all cities and counties. There was a question about why we were talking about San Mateo and Huntington Beach. San Mateo was they were a defendant in a lawsuit we talked about. We weren't comparing anything the town was doing with what San Mateo's doing. Huntington Beach was just being referenced because they've been probably the most aggressive city in trying to sue the state against these various housing bills. There was a question about specific adverse health impacts for people over 65. Yes, the city could develop health standards, for pedestrian access, whatever, based on some of those studies.
Can you determine those standards subsequent?
No, the problem is you have to get those standards adopted before someone files a preliminary application.
So
we could
if
do
we
it.
had a preliminary application now, anything we do currently
doesn't count.
But we could get in front of any future. Okay.
Yes, the goal is to get in front of future projects.
So, and that pertains to all of the fire, safety, evacuation, all any standards that we come up with.
Right.
Okay. Thank you.
Thank you.
And Barbara, I'm going sequentially here. Did you catch the one about the 5,000 square feet of commercial space?
Yeah. So yes, the density bonus law does apply to a mixed use project that includes commercial. And in fact, in fact, people can request waivers, at least people can request waivers for the commercial part of the project as well. Initially, that was just an HCD view, but there's a couple bills on the governor's desk that are trying to limit that. But by limiting it, they seem to imply that, one of them says if you're giving if the commercial part of a project requires, asks for a waiver, you can only give this much of a waiver. Well, that implies that the commercial part of a project can get a waiver. So the fact that there's 5,000 square feet of commercial doesn't make a difference. Yeah, in fact, any project that has 5 units theoretically is eligible for density bonus waivers and concessions. Now, if it doesn't qualify as a housing project, then it's not subject to all these other protections and could be denied. But anyway, the statutes are very loose. There was something about what the town decided versus state requirements. In the housing element, that's, I wasn't part of that, so I don't really know.
We can ask our planning director.
Yeah. And in terms of suspending the overlay, that's not really possible. This town can't downzone a site, take away that density unless at the same meeting it increases the density on another site to make up for that loss in general. Also, if it's a suspension, then it would be a moratorium, and moratoriums now need to be approved, if they affect housing, need to be approved by HCD. And it has to be based on a specific health and safety finding. I'm not I know a client that managed to get a moratorium approved when a sewer was failing, just as an example. There was a question about solar access laws, and that's a good question, but I don't know the answer to it. And then about developers using up a meeting by calling for a continuance. I think a city under that circumstance could refuse the continuance, actually, unless the developer agreed that the meeting wouldn't count as one of the 5 public
Yes,
meetings.
but Barbara, I think the question was more geared to what you covered already that maybe that person missed, which was the 5 public meetings only applies to certain projects. So for example, a ministerial project,
Yes.
Can you do 5 public meetings for a ministerial project?
Well, they've changed the statute where there's almost no time to do any, I mean, forgetting about your ministerial
Right.
process, but in the state ministerial processes, one of the changes made by AB 130 is that if the application's complete, so someone submits an application for a ministerial project, let's say it's their second application, and the application, after 30 days, which is what the town has, the town determines it's complete. At that point, the city only has 30 more days to approve or deny the project, which barely gives time for one public hearing.
Okay.
And then in many cases, for instance, with SB 35, which is this streamlined process I mentioned, there's a provision that says whatever the planning director decides goes, basically doesn't allow the commission or the council or any other board to overturn that.
There was another question or sort of implied, and I think there's a lot of confusion about the height limits.
Oh, yeah.
That there was an idea that somehow we could have set height limits that the state could not override. Is that true?
But I think before you go there,
Just
just about the housing element, we did not change the height limits in the housing element. So I think your question is more about, I think there's a misunderstanding that we changed the height limit in the housing element. We did not.
Poll.
And so go ahead.
Yeah, yeah. So I mean, I'm just going to, she's kind of unpacking what I've heard a lot of, which is there's a confusion that somehow the height limits were removed from the code or removed from the housing element, which is not true. And that other towns, for example, San Anselmo has been able to hang on to its height limits. But if a developer came to San Anselmo and said, I'm going to make use of density bonuses, it would be by height limits, right? If that's what they wanted. Is that correct?
Yes, that's correct. And then San Anselmo would be facing the same situation that you're facing.
Thank you. And then I wanted to clarify another question somebody asked about why are we doing this now? Can you, I mean, I know I've looked on our website. I'm just going to put out there that we have had more than 25 public meetings on the housing element. So this has been going on since 2021. And we're having this one now because we all pushed for it for a while because we thought it would be useful. I don't know if there's another answer from staff, but I just wanted to put out there that there have been a huge number of meetings on this. It's just that it becomes more relevant to people when there's actually a project on the table. And that's, I think, why we're all very concerned now, because I think before it was just kind of like, yeah, those people are going to talk about that planning BS, it's boring. And now it's kind of like, oh no. So,
and there was also there was new policies passed in July, like this, they gutted CEQA too.
It's not specific to the project. I'm saying that the project made the whole idea of housing laws more relevant to people because suddenly it has something substantial that people can look at and say, oh, that's what all that gibberish meant. So, and I want to just make sure that a couple of things that people asked get addressed, and then we're going to move on to comments from commissioners and council members. Somebody wanted to know about imposing a condition of approval. Do we have conditions of approval? Can we add new conditions of approval for projects that haven't been proposed yet?
Yes, you can adopt standard conditions of approval. You can adopt new ordinances for projects that haven't been filed preliminary applications.
Okay, and then another thing that somebody brought up, and then I'm going to let it go. So there were some questions about, stacking density bonuses. So that was one that maybe our staff would have to answer. And then there was another one about that or it wasn't so much a question, but somebody said that most other towns and cities for their housing elements only have 1 or 2 sites, and we have 13. Is it correct that most cities have 1 or 2 sites for their housing element?
Well, maybe very small cities. Most of them have a variety of sites. I mean, it all depends on, the characteristics of the community, right? But typically, for lower income housing, you can't designate a site larger than 10 acres. So even if you're a city in the Central Valley with a lot of vacant land around you, you typically would need to designate a number of sites. But I'm not aware of what the surrounding communities here, have designated.
Thank you.
There was one more question that, along with the idea of 13 sites, there's some, I guess, speculation or question that I heard. Does that mean there's 13 more high rises planned? What Barbara just talked about was that for affordable housing, it has to be a limited size, so there would be a number. But I don't know if this is a question for Barbara or for our planning director. I think what we have is the one, and because of density bonuses and waivers and concessions, it's bigger than what we envisioned. But Barbara, is this something you can answer? I'm not sure.
Well, it would all depend what the owners of the property intend to do with it.
Okay.
Yeah.
Thank you.
So I think we've gone over the questions from the public. So I think we can come back to questions or comments from commissioners and council members, but I thought it was extremely important to get to the publics because they haven't had a chance to speak till now, and now we can go back to discussing it ourselves. Commissioner Newton.
So thank you once again for this really interesting deep dive into state housing law. And at the risk of sort of opening up a can of worms, what's next? What do you think is coming down the pike?
I think you probably need to talk to the League of Cities lobbyists about it. There was this AB 79, which ended up exempting Marin, but for people in Santa Clara, San Mateo, San Francisco, Alameda counties, it allows these very, very dense projects next to train stations. The state seems to be taking over. I think what bothers me is that cities have spent a lot of money and a lot of time on housing elements, and somehow that's not enough, and then the state still, despite all this effort, then is requiring what a few legislators think is the appropriate kind of development near transit stations. So, yeah. Oh, I did mean, Commissioner, you asked about the reuse projects and what that, for the sites that have been designated in former housing elements. The language here is that for these sites, it was if they were not approved to develop a portion of the locality's housing need. So I gather that if the town had actually approved a project on the site to develop a portion of the locality's housing need, and it doesn't, anyway, that then they wouldn't be covered by this. But that's the language.
Thanks.
Okay. Yes. I'm sorry, Commissioner Jansen.
Thank you. If the town would have met its RENA numbers, let's say 2 years from now, can we disapprove any subsequent project? And and the waivers and the bonuses. So in order, if you met your target, can you then terminate this process?
You would need, I think if the project conformed with all objective standards, including all the density bonuses and so forth, you'd still need to make a health and safety finding to deny the project.
Okay, so it's a no. It's not. There's no end to it.
There's no end.
Yeah, and that of course goes back, and I think I know the answer to that, but maybe good to reiterate and it's been mentioned a lot, the stacking of the actual RENA numbers plus the bonuses and the waivers. There seems to be a mathematical error in how this whole thing is set up, right? If the town, do round numbers, if the town would need to build 500 units by RENA, then we make a plan how you can build those 500, but any subsequent developer can come in and go for a bonus and actually build 750. And so in reality, we should have planned for 350, but so you can't. It's not allowed. So basically the law, if the numbers we're getting say you need to build 500, what they're really saying is you need to build about 800.
Yeah, I mean, the law allows developers to build many more units than are shown in your housing element.
Yeah.
And HCD also generally will not allow cities to consider density bonuses when looking at the capacity of sites, which
Is that
seems
defined?
completely unrealistic to me.
Can you point to where that is? Where is that? Where is that?
Where is that? That's just their policy.
That's HCD policy.
Yes. Yeah.
They conveyed that to us as a condition of certifying the housing element. Yes.
So that's
That sorry, you say it.
That's not defined in state law. That's just an agency interpretation.
Yes.
Wow.
That you can't calculate the bonus density in your.
Right.
Janet, you need to speak into the mic. We are recording this. We're all sharing.
That is exactly what happened in this case. We asked specifically and we're told no.
Right. So it's like if you need to hit 100 units, right? You plan for 100 units, but it could be way more than that because of the density bonuses, right? So you're not allowed to sort of project that the developer might take advantage of density bonuses when you're planning. You have to just assume the lowest possible number that they could build, basically, and go from there. Okay. I'm sorry. I just was clarifying that. I see Commissioner Bella has a question. And I'm sorry, Commissioner Jansen, were you done or not done?
Yeah, I think I'm done. Thank you.
Okay. Sorry.
So I have some comments and I do have a couple questions in here. First of all, I just want to thank the members of the public who came up and gave what I felt like was a very measured sort of framing of the topic and the issue. Whereas it doesn't make sense to sort of target our council. Really, if we want to try to take action on this, we need to work with our legislators and really, work with the state. I really just applaud that. I also want to, reinforce the comments that seem to have a measured approach regarding, acknowledging that we do need housing in Fairfax. There is a housing shortage, and we are in a very high demand market here. Also that there's good evidence, when a city manages to build housing at scale, rents can actually decline, like the case of Austin. I know we're not Austin. I know we're not anywhere near Austin, but Austin has seen a 7 to 8% decline in rents year after year because they've been building housing. Another point I want to make is that, where there's, many new laws are attempting to remove the barriers to housing. That's different than the housing actually getting built, as you pointed out, Barbara. And, just because the town approves a particular type of housing here in Fairfax, it doesn't mean that project's going to get built. As a matter of fact, downtown Berkeley has something like, I don't know, 3 to 5,000 approved housing units in very tall buildings. None of those are getting built. They're totally stalled because current construction costs don't support that type of housing. So getting to the question. So let's assume that, the town approves one or more of these current proposals that's taking advantage of density bonus laws. Let's say that housing doesn't get built because the construction market doesn't support that type of housing today. How long before the approvals would expire? Is there sort of a sunset date for the approval of a particular project's entitlements? That was one of the questions.
The preliminary application only lasts for about 2.5 years after the project's approved. Yeah, they basically, but, and then of course the town probably has their own provisions about how long, an approval's good for and whether people can get extensions, so forth. What we've been seeing lately is the legislature keeps extending those. But in terms of the applicability of the preliminary application, it does expire after a while.
Yes.
And I just want to add that we changed it a few years ago with our prior planning director to, I believe, once they got the entitlements, I think it was only good for 2 years.
Okay.
So we didn't used to have those guardrails, but we changed that a few years ago. And I don't remember the specifics.
Okay. Well, my point I'm trying to make is that even though a project gets approved today, it may not get built because it's just not, it doesn't pencil today. It doesn't work out. And eventually those approvals may expire. That's actually happening in many places in the state that had approval for higher density housing. They're now rethinking those projects to come up with a kind of lower density, which might be more sort of context specific. So the big point I'm trying to make here is that, I think it'd be helpful, a reframe is necessary here. That rather than putting our energy into trying to fight the state, which I don't think is going to get us anywhere. My sense is that, what you've told us, Barb, is that we really need to update our objective design standards to the extent that we can, so that we can invite the type of housing we would like to see in our community and try to create the conditions where we're bringing in smaller scale developers, smaller builders that are going to build the type of stuff that seems to resonate with the sort of town's sense of appropriate scale and density. And could you speak to some of the state laws that seem to be sort of moving in that direction? Like I think it's SB 684, which is a law which supports smaller scale developers and builders. And could you just speculate on what are some ways that how might we as the town of Fairfax actually create the conditions for the types of housing we would like to see versus putting our energy into trying to fight the state, which I don't think is going to really get us anywhere?
Yeah, I mean, the 684 basically tries to incentivize small subdivisions of 10 units or less. And it's actually not a very workable statute the way it's drafted, but that's the intent. Sorry, you're asking me a bit beyond a legal question. Yeah, I think the town, if there's development that the town thinks would really work and set up a process to make it easy for those developers, for those projects to get built, yes, that could encourage it. One thought I had is the state's creating all these ministerial projects. Communities could create their own ministerial or almost ministerial projects or systems for projects that really meet what the town wants and don't claim any waivers or concessions or whatever, kind of an easy alternative process for what you would like rather than for what you don't like. But
that's great. So a streamlined ministerial approval process that makes it easier to build the stuff we want to build, and then even using the sort of state waivers and density bonus kind of process.
Yeah.
Interesting. Okay. Thank you.
My only thought.
Okay, Commissioner Pfeffer.
Thank you. I know you said it was an interesting thought, but you didn't have specific experience in this solar, installation issue for tall developments. Having been a lawyer on this finance side who reviews, the forms before, 10 years ago. A lot of the lease arrangements and the solar projects where you're financing through the solar company have requirements in the contracts to prevent insulation of the panels, because they own them still on your unit. Has there been litigation? Are there exemptions for interference with contract generally? If you say, I am bound by my mortgage not to allow X, and
I just haven't encountered that issue.
okay.
Yeah, so I don't know. Yeah, I mean, generally there's, yeah. Do you want to say something, Janet?
Well, you can't contract in violation of law, right?
But the contract being pre-existing.
To the state laws?
Yeah.
An interesting question.
Yeah.
Okay. And for the meeting the RENA numbers, I don't know, we're also seeing a lot of laws get passed about permitting ADUs and legalizing units that haven't been in compliance with code. If there are unpermitted units, like if I had a big house and I, without permits, took down the bottom floor and made it 2 separate rental units without permits, when those get legalized, do they count for your RENA numbers?
I think so. Somebody once asked HCD that. They said unless they were already counted in the census, which I don't know how you would figure that out, they should count in your RENA.
And I just want to add, we have a process for legalizing illegal units. And I remember when we were working on the housing element, we specifically looked at this issue, and they will count once they're legal. You can't count them when they're illegal.
And last one, when you talked about, it's both on the public comment or question about changing the workforce housing overlay, and you mentioned you can't downzone a site without reciprocally upzoning sites. And also the question about, closing loopholes about all the myriad concessions and waivers, and I guess sort of adopting objective standards that would prevent some of that. When you do that, does HCD get to weigh in and say, hey, now, we're showing that you've not zoned for 490 units?
I mean, a developer can request waivers for your objective standards, from your objective standards, right? That's the difficulty with doing objective standards, is you can't promise anybody that they will remain in place. About the only standards that you can really enforce are health and safety standards. Let's see, the other question was.
Well, the other type of requirements, so you mentioned broadly, I think much earlier, that part of getting the preliminary application is that the design standards and zoning and all of that is set in stone at the preliminary application date.
Right.
Are there broadly categories of regulation which may indirectly affect development that do apply? And I'm thinking specifically of, for example, tenant protections, which are the HCD says they want in their affirmatively furthering fair housing guidance. If the town repassed them now, would they apply to developments that have preliminary applications in?
I think so, because it's not a development standard, but you'd have to look.
Got it.
Yeah. But precisely.
Yeah, I know when we
Yeah.
were discussing it at the time, they said that having that doesn't negatively, it's one of the things that doesn't negatively affect the amount of units that HCD says they think you can
I don't know.
list a site for. So,
Okay.
I'm going to encourage people, if you need to take a bio break, just go and do it, because we have a great conversation going on here. So are there other people right now who have questions for either our staff or for Ms. Couts? Mr. Egger,
Well, talk
Councilor
about
Egger.
objective standards. Does Fairfax, has the Fairfax Planning Commission approved a set of objective standards? Is that all done in place? Okay, so you must know what your objective standards are. I haven't seen them, but are they in the
They're
town
they're
code?
in the housing element, municipal code now.
They're in the code itself.
They sure are.
I'm kind of wondering about some things, like if there's anything we can do more exploration on. Does that mean hiring another consultant? I was really interested in some of the, comments around safety standards and fire safety standards, evacuation standards. I'd be really curious to know whether people have actually been able to set defensible standards of that sort. I think that those would only apply to projects that have not yet been proposed, right? But I'm just curious, like, is there a way to do that, since many people seem to be very interested in that?
Yeah, I believe you would just, adopt an ordinance or standards by resolution.
I think the issue is finding a standard. Now, I think what you're talking about is, say, evacuation standards or something like that, right? Time.
Right, right. And I'm just wondering if that even
Okay.
exists. Like, is that something that's even defensible? I'm just curious about it.
And you have to think about whether or not you meet that right now or not.
I'm sorry, can you repeat that? Whether
You have to think about whether you meet that already or not.
Okay, so that would be one question for us, is do we meet it already? And, I'm just looking at solutions that people have suggested that would give us some more control. Some people talked about, historic sites. I hear that's a really grueling process, and sometimes people really don't want to do it because it limits their ability to change their property. But that is one route we could take, right? If we really wanted to go through that whole process of designating historic sites. I think it's kind of a bear, but it could be done, right?
Yes. Yes, you can, do a survey. There's standards for the survey, and then decide if some projects, buildings or whatever are locally significant or maybe even eligible for the state register.
We already have those programs in our general plan now.
Great, thank you. And then another thing that somebody mentioned was just, do we have conditions of approval, I guess, rather than conditions of denial? But I think we do have them.
Good question.
Well, yes, as the Planning Commission knows, we do have standard conditions of approval that we apply to all projects, and we can always develop additional standard conditions of approval.
Great, thank you. I mean, I thought I knew that, but it's always worth reaffirming. Other questions? I see Councilmember Garaghelli.
By the way, I think we had a chance to vote against the safety element, but we passed it 3-2. So we're talking about the safety element as being one of the standards that we could use to help prevent some of this, but we literally just passed it. We tried to stop it, but 3-2, it was voted on. So I just want to make a couple comments and maybe a question. Obviously, there's lots of layers here. And many people I've talked to, many people do not believe. Many people have pushed back on the RENA numbers. They're far too high. They're made up numbers. A lot of people have challenged them. And in general, they're just numbers pretty much out of thin air. I also believe, like a lot of other people, that there really is no housing shortage. I believe that the state politicians, for whatever reason, I'm not sure what, but I feel like they're out of control They needed to be voted out of office. We talked about what can change this. It will be the power of the vote. For some reason, they're strong arming all these towns and all these citizens. A couple of questions I had is, we mentioned this. In fact, one of the planning commissioners pointed this out. I talked about Austin, how they're having housing, a lot of available housing, which has driven the price down of cost of living. What if the state, it was mentioned earlier that there's 140,000 empty apartments, 60,000 units are empty in San Francisco. That doesn't count houses and condos. So there's a lot of empty houses out there that aren't filled. And I think one of the objectives is if we build more and more and more, that will reduce the cost of housing, supply and demand, right? And but if you do that, if you overbuild the housing, do you collapse the real estate market and lower the prices of real estate? Which, for me, I don't care. I wish real estate was less money. Does that also collapse the funding for our government? Because we base everything that these towns do and government does, most of it in this county, a lot of it is based on property taxes, and that's the bulk of it, I believe. So I think that it's very complicated, but you can't just sit there. One thing I don't believe in is that you just sit there and get punched all day long by the state. I think you could respectfully disagree. You could start by letting them know that. And I do believe with what other people have said is, not just each town go at it alone, come together and do it as a group, do it, every town, every city come together and fight it. And something else I believe that we forgot to address, or maybe it was addressed, but it came off the table somehow. But you're talking about how you could you can, I guess, kind of redo zoning a little bit if you had a alternative plan to replace some of what they're demanding from us. And, when I ran last year, at the same time last year, I was running for office, and I was suggesting that we work closely with the owner of the Marin Town and Country Club. Everyone knows that's been, empty since 1972 or 3. And that is 24 acres of land that could be used for some sort of mixed type use, which I won't get into right now, but just different ideas, including truly, hopefully, in my mind, low cost housing. Housing won't cost less if you keep building it for more. In other words, if you just keep trying to build to a certain, so what you need is, in my estimation, is areas that just cost less to build, and whether they're prefabbed or whatever you want to call them, there's plenty of places that have this kind of housing. Santa Rosa, Petaluma, Marin County has some. I just had one of my valuable staff member, just purchase something for like $300,000, and her and her daughter are going to live there. And my point is that that's low cost housing, and it's not built like a Taj Mahal. It's built a little bit differently. So I don't think we should sit there and take it. I think we need to find clever ways, good ways, convincing ways to tell the state that they're out of their minds. And by the way, it was also pointed out that you can't even build these places they want anyway. They're still short of what they're trying to get to. So I'm sorry to say this, but like most government things, they don't know what the hell they're doing. And that's just the way it is. And so we need to rethink this whole thing. And, Governor Newsom, he's a smart guy. He knows that this is not a good idea, what he's doing to these towns. Why not build new cities? I mentioned that. Some people push back on me on that. Why not build smart cities where Google sets up places where people have places to work? Okay. Fairfax, everyone's got to leave town to work, pretty much. Okay.
So-
Those are my thoughts, and I like to just wanted the public to know what I
Right.
was thinking.
And I'm going
Thank
to move
you.
to Councilmember Kohler, but
I just want to say.
can I finish my
Go
thought?
ahead.
I just want to say that it would be great if you have all of these ideas, if you have actual actionable ideas about what we could do, like what would they in concrete form be to do that pushback? That would be helpful to think about. So, Councilmember Kohler?
Yeah, I think I just want to say we did appeal the RENA and we were politely told no way, which everybody was told no way except one city got to change this a little bit and went to the adjacent city, and it wasn't very much. But I just want to say, Barbara, thank you for your excellent presentation. We had a presentation on housing laws many years ago, about 2015, before all these things went wild. But even then, density bonuses, waivers, and concessions kind of blew my mind. And now, every year there's something new. And SB 79 actually excluded Marin with the exception of where there's ferries. So there are some cities where there are ferries. That was one change that was made. Oh, you think?
I think so. I think they got rid of it at the last minute.
They got rid of Tier 3, but
They got rid of the
last I heard
ferries.
from Cal Cities, it was still in
Got
there.
to have 15 train stations.
Okay. All right. Well, that's great. But anyway, I just want to say thank you. And I kind of think we can beat this thing to death and go on for hours and hours. But I think you have really given us a firm basis. And I want to ask our staff, can we post this presentation on the website? I think it's really important.
Yeah, thank you. We did post the presentation just before the meeting.
But let's post it somewhere where people can find it, not just with the agenda item. Let's put it like on our housing element website page so that it's easily found by people who aren't following the details. If we can do that too, that'd be excellent. Anyway, I just want to thank Barbara, and I feel like I learned a lot and I'm ready to wrap this up.
Okay, so are there any other questions or comments? Okay, just a sec. I see Councilmember Hellman and then Commissioner Bella.
Yeah, I want to thank the public. I thought there were some really good questions and concerns raised, and the Planning Commission for being here with us tonight. Always appreciate your perspective and expertise related to this. And yes, Barbara, you were amazing, and I learned so much this evening. So thank you. And we can't, because this is a special meeting, talk about future agenda topics, but I think we all got some good ideas and fodder for the future. I'll just leave it at that. Thank you very much.
Thank you, Commissioner Bella.
I'll be real brief. So just wanted to pick up on a couple of things that Councilmember Girangelli and Councilmember Egger said that, I think this is going to require a lot of creativity to really kind of get ahead of this. I respectfully disagree about trying to fight the state. I'm not sure that's going to get us anywhere, but I agree that we got to get creative. We got to be proactive on this. And Councilmember Eggers, this group spent the last year or more trying to develop those objective design standards and get them into our municipal code. I think they could be better. They need to be better, and I think they could be more legible with like diagrams and graphics. Right now, it's just really code text, which is hard to understand. So I think there's work to do actually on kind of making those more visible, so more folks from the public understand what they are, because they are an important tool for us to have agency in shaping housing policy. So just wanted to put that out there. I know I'll put a lot of work into creating those standards, but I think they probably could be better. And so, yeah, just wanted to put that out there. I think those are the tools we have to really kind of get creative and take action.
Great. And Councilmember Egger, and I'm sorry,
Yes,
I sometimes just can't see you and I've got to.
Okay.
I'm sorry if I didn't get you.
We had that safety element before us just a while back, and this is an area where our safety element failed us. Folks living on a wildland fire can move about a mile a minute, depending on the wind speeds. And if a fire comes off this mountain, it heads towards Manor Hill, those folks won't be getting out, flat out. That's like a one-lane road up, one lane road down and if there's an accident or something that's blocked, they're not getting out. Same in the Cascades. There's one road in, one road out. We're not going to get out into Cascades if a fire comes blowing out of the nature preserve it into the Cascades. Deer Park is the same situation. And the state seems to ignore the fact that some of these little towns like Fairfax were built as resort towns where we don't have the width of the roads to get people out. And actually our evacuation plan didn't even tell us how many people were going to have to get out of Manor Hill or out of the Cascades or out of Deer Park. And how many folks that may be disabled, how many folks that are aging, that are going to need help getting out. That should all be part of the evacuation plan. And we had the trial last month, and the siren in the Cascades never worked. That they ran an evacuation, didn't even work. So we're like sitting ducks in some of these hill areas and outskirts of the main drag. So we've got to somehow tell the state what's going on here and bring them down here and take them for a little ride and ask them how the heck they're going to get us out, because we have one and maybe two police officers on duty at night. That's it, period. There's no way our one or two officers are going to evacuate a neighborhood in a wildland fire. It's I think we've got to really deal with this and deal with the state and get them down here and show them what's going on in our town.
Thank you. Okay, so I think we're okay. I see you, Commissioner Pfeffer.
Just want to get a couple of last minute thoughts since we have the council here and the discussion about the safety element in particular. Just process wise, we had an older safety element that was in place. So passing the safety element just applied some updates. If we didn't pass it, we would just have a more out of date safety element that would have even fewer standards that we could apply. And like Commissioner Bella said, everybody on the Planning Commission said over and over again throughout our process of recommending amendments to the code that there's many more improvements we think we could make. And the town council, I know, could at any point say they want to amend the safety element and then propose amendments to the safety element. And then just want to add context on fighting the state, which I think, makes sense, if you're picking your battles. But we heard about one case costing Huntington Beach $3.5 million in attorney's fees, and that doesn't count their costs for their own attorney. And that's our full fire department budget for a year. So it's just something to consider, including it in the budget for, hey, maybe housing law challenges. And I know some municipalities have lobbyists specifically for that issue in Sacramento constantly arguing on their behalf. And I think that's something that certainly could be budgeted. But if we're focusing on safety, we don't want to not have a fire department just to stop one development.
Thank you. So I am going to close this up. I just wanted to say what I want council members to do is that, if you can think of actionable steps that would help address this and make it better, bring those actionable steps, like propose them at the end of a meeting where we can propose future agenda items, be transparent. What is it that you would like to discuss? And do you have a concept of what the budget for that would be? I did want to mention that we have talked to Mike McGuire and invited him here. I don't know if he'll come here, but people are actively trying to talk to the state legislators. And that's it. I want to adjourn the meeting in memory of Joseph Murphy and thank everyone for I agree that the public had amazing comments. That was an amazing presentation, and this was a robust conversation. I really enjoyed being able to talk with the Planning Commission, so this has been great. Thank you.